Good evening, everyone. I'll call this special meeting of the Township Ocean Board of Adjustment to order. Claire, can you take a roll, please?
Vice Chair Fuller.
Here.
Delomo. Littman. Here. Ashkenazi.
Here.
Zamora.
Here.
DeGenero.
Here.
Pugliarelli.
Here.
Lineski.
Yes.
Terranettica.
Here.
Chairwoman Beal.
Can we please stand for a salute to the flag?
Allegiance to the flag of the United States of America, to the republic which stands one nation, under God, indivisible, with liberty and justice for all.
The notice requirements of the open public meeting law for this meeting have been satisfied. A copy of the notice having been sent to the Asbury Park Press and the Coaster and filed in the office of the Township Clerk. There's an emergency. If there is an emergency, there is an emergency exit through the courtroom doors and 2 exits at the rear of the room. No smoking is allowed. Board policy is no new cases will be started after 9 p.m. No new testimony taken after 9:30. I think that will not hold for this evening, though, right? To do the yeah.
It's your call.
We're gonna do these. Let's go. All meeting will be video and audio taped and shown on the Township Oceans Community Cable Channel, Channel 22 on Verizon Fios, Channel 77 on Cablevision. Please turn off all your cell phones. If you need to make a phone call, please step outside the meeting room. We begin with our continued case, IAAT Services LLC, 1700 Highway 35, Oakhurst, Block 34, Lot 12, Zone C3. Mr. Chukowski?
Yes, good
Hello.
evening, Mr. Chairman, members of the board, Brian Chukowski, Cleary, Jacoby, Alfieri, and Jacobs on behalf of the applicant IAAT Services. Thank you for scheduling the special meeting. We were last here July 18th, and we got through most of the testimony of Mr. Volt regarding 1700 Route 35. I have had a conversation with Mr. Steinberg. We have 3 applications. Those applications, 2 are for the multi-message, which are the LED boards, and 1 for the static. I believe we can probably streamline the other 2 once we get through the full testimony on 1700. But since each application is separate location, we'll have to treat them that way. So when we were last here on the 18th, there were a series of questions that were asked Mr. Vogt. Mr. Vogt did his research. There was a list of exhibits that were requested. Mr. Vogt provided that on July 23rd. In addition, we did show some videos from the manufacturer of the board, which was Watchfire. Mr. Vogt also consulted with Watchfire. If a question comes up regarding something that Mr. Vogt cannot answer, which I believe he would, we do have people available from Watchfire by phone that we will have someone contact so that we can certainly get the information for the board. So unless there's any questions of me, we do have Mr. Vogt tonight. We have Brian Intandola, our traffic engineer, and Andy Schaefer, our planner, to address the issues regarding each of these cases. So Mr. Vogt was certainly sworn, and we could.
You remain sworn in, right?
He's been sworn in. You remain under oath.
All right,
Yeah.
thanks.
And I'll just say there's a few members here tonight that weren't here for the last meeting, and everyone has signed attesting that they viewed the first hearing.
Okay, thank you, Mr.
Sure.
Fuller. Now,
A quick
Mr.
question, are we gonna do these together?
No, he just said.
Okay.
You gotta listen. he just indicated he's going to try to streamline each of the others, but each is slightly different, and each
I
has to
get
be.
that, I just don't wanna be repeating this all night.
Well, you may get some repetition if he's making a case.
That won't go well.
He has to do it.
I am going to try to avoid
Sorry.
repetition, and I think the easiest way to do it is to
Do we have to mark it again?
finish 1700, which will have
Same.
the full and complete testimony. Then we'll have 922, which is also a multi-message board. And then we have the static billboard, I forget the exact address, I think it's 1418.
That's correct. But each requires some different variances, so they have to be.
We don't have to vote on, we can vote on them separately, but I just don't see why we have to do.
Well,
The applicant.
Let's finish
It's
it.
kind of the
Let's finish
process, so
one
let's get
first.
rolling.
Well, I just don't wanna get too far into it and see that we're repeating stuff all night.
No, I understand, Mr. Vineski.
Yeah, he's gotta make a record on each one, that if the board's decision is appealed, regardless of which way the board goes on the applications, there has to be a complete record on each one. So there's gonna have to be some repetition, and there's no avoiding that.
And then
It's not his choice, it's the legal requirement.
the things that were submitted since the first hearing, do we have those? Do we have to mark those or anything like that? Or
Those
that'll
were
be
a
introduced?
list of exhibits,
Yeah.
and what I wanted to make sure is that you had the most recent lighting studies
Okay,
from
perfect.
Watchfire, which I provided to Claire today, which Bill was addressing at the
Okay.
last meeting.
Okay.
So, Bill, you recall your testimony on July 18th, correct?
Yes.
And at that time, there were a series of questions by the board regarding several issues, and let's walk through them. I guess the first issue was one of the lighting intensity of the sign at, below the sign.
Correct.
And can you answer that question and advise the board what research you did in order to respond?
Sure. Good evening. We presented a couple of exhibits last hearing. I believe these are exhibits 4, A4. It's the Watchfire diagrams showing the lighting in both directions. And a question came up, the lighting levels that are shown at the different distances. We have a chart that basically tells you at the different viewing angles at certain distances where we have 100, 200, 300, 400, and 500 feet at the different viewing angles, 0, 20, 40, 60, and 70, we have foot candle readings. Those readings are directly in front of the sign as well as on the ground where the person is viewing the angle. The billboard company, when they do their lighting analysis, they take a conservative approach and they transpond the lighting level that's directly even with the face of the board down to the ground. So it's the worst case scenario. Okay, so the lighting levels that I testified to will be the highest levels in complete darkness at both directly in front of the board as well as at the eye level of the driver.
There was also a question, Bill, regarding the redundancy that's built in with respect to the operation of the billboard. And I guess that's twofold. Number one would be power, and number two would be the programming, which is through a broadband technology, correct?
That's correct.
So could you address both of those?
Sure. So the way that the operator communicates with the board is through a broadband signal. It's a cell phone signal. So it's the most secure signal, not easily hacked and broken into. What happens is they push the content onto the sign through the signal. It runs those 8 consecutive flips over, let's just say it's a month. Once it's loaded on the board, it continues to run those 8 flips until it's told to do anything differently. That board, its communications on within the panel communicate back with the operator and sends back signals through the same broadband connection. And for instance, it will tell it about the operations of the individual diodes that are on the board, the photo cell, how the board is operating, and so forth. So that is the communication between the two. So if there is a, let's say the cell phone signal goes down, okay, that sign will just continue to run those ads over and over until someone has to physically, if there's no signal, they would physically have to go to the site and then they could hardwire into it to change it. Now, if there's a complete power outage and everything goes dark, it will, once power comes back, it will reboot itself. It will turn on, it doesn't flash, it warms up, it'll start from a black screen, and it'll consistently warm up to whatever the ambient lighting is of the time that it turns back on. So it communicates much like your server does. If you have a server at your office, it communicates with your IT department.
And you also testified at the last meeting that the intensity of the light will depend on the time of day.
That's correct. It's all programmed in ahead of time, what time zone, where in the country it is. It also has that photocell on it for any ambient light shifting during the daytime hours. Let's say it's an overcast day, it will automatically adjust because a time-sensitive table is not going to tell you that.
And I know you testified to this, but you used the word earlier, 8 flips. Could you describe that to the board?
Sure. So there's each advertisement stays up for 8 seconds. So there's 8 advertisements in what they call a 64-second minute. Okay, so every 8 seconds, instantaneously, less than a second, it instantaneously changes to the next advertisement.
And I know Mr. Intandola will testify to this, but the change over 8 seconds will not distract drivers or people looking at the sign, correct?
No, and you'll hear testimony that there's no evidence supporting that claim as well. Sure.
You can hear.
You can hear?
It was solid.
It's on.
Thank you.
So Bill, also, just to recap, we were also speaking about the height of the sign, and you identified along the northerly side, or North Route 35, I should say, that there were some distinctions with respect to the utilities that exist on that side of Route 35 as opposed to southbound Route 35, correct?
That's correct.
And the height of the sign was determined in order to adjust for those utilities.
That's correct.
Right. In addition, well, one minor item till we get to the next one. We've indicated, the board requested a landscape plan for the base of the sign, or one of the board's professionals. You've indicated that you would provide that, work with the engineer or planner or both in order to develop a landscape plan if the billboards are approved.
That's correct. The applicant has agreed to satisfy any landscaping requirements around the base of the sign as deemed necessary.
And also, if you recall, there were reports from the police department for security, and you indicated you could address those security concerns at the base of the sign.
That's correct. I think one of the security measures were to protect the ladder rung, the access to the sign. The ladder rungs start high up. You need an extension ladder to get to the first rung. So in certain cases, I would not create a cage around the base of the monopole. What we could do is we can put like a sheet metal cage around the ladder rung that's at the upper level, and we can certainly put a light shining down. I think that was another requirement from the police department. Completely up to the board and the police department. I mean, we could put that on like a motion sensor, so it doesn't need to be on the whole time. You know, so there's definitely measures that we can do to accommodate the comments from the different departments.
And one of the last concerns the board had was an exhibit identifying the billboards on Route 35. Do you have that exhibit?
I do. You want me to
Yeah, you can hand them to Claire. And I believe that will be A7, Mr. Steinberg?
Claire has the list from last week.
I believe it's A7.
Is A7, Claire?
I'm sorry?
Is A7? Claire, keep
I
it.
think we were up to A6, I just wanted to make sure.
I gotta go through those notes. I'll start with this one.
So we've marked that exhibit as A7, Bill. What does A7 depict?
Correct. So A7, again, it's an aerial photograph from Google Earth that I took down this week. And what we did is we accessed the New Jersey Department, NJDOT website for their outdoor advertising sign locations and permits. And what we did is we indicated all of the permits and sign locations along the Route 35 corridor, both in the north and south directions.
So let me stop you there, Bill. What you also handed out was a list of all permits that exist on Route 35, correct?
That's correct.
So if we could mark that list as A8, Mr. Chairman, and then we could correlate that to A7.
Really, it's the same information. I just gave it to the board in case you couldn't read the information that's on the map. It's the same information.
We're gonna
It
mark
was
this
just for
A8,
clarity.
which is list of billboards on Route 35.
Well, list of permits, we'll get to that in a minute.
Oh, okay. Yeah, we have some never applied, never built.
Correct.
That's correct.
All right, so why don't you walk us through, in any manner you see, going south to north, north to south, east, west, however you feel.
Sure. So I'll just start from left to right at the bottom of the page. Left being, to the right of the page being the southern direction. So you're traveling south on Route 35. To the left of the page, traveling north on Route 35. All of the billboard permit locations and/or constructed billboards are designated in yellow dots along the southbound travel direction. What I did is I highlighted or I bolded the 3 properties that are before you in the application. So I'll just start from the left-hand side of the page. We have a DOT permit for 2122 Route 35 South, and that's a multi-message, and that permit's held by IAAT. I'm sorry. It's not constructed, just a permit is held for that location. As we continue down, we hit our current application, that's 1700 Route 35 South. Again, that's a double multi-message sign, also by the applicant, not constructed. Further down south from our current application, we have a constructed out front billboard. That's a double static, and that's located at 5919 Willow Drive, but it has frontage along southbound Route 35. Continue further to the south, we come upon our other application before you, that's 1418 Route 35. That is permitted for a double multi-message sign. We will get more into that when that application comes before you. Further to the south, there's an existing out front double static billboard that's located at 1126 Route 35. Continuing farther down, we come to our third application. That's 922 Route 35. Again, that permit is for a double multi-message by the same applicant, not constructed. The last 2 are both by out front. They are located at 2301 Route 66 and 6258 Route 35. Both at the very end of Route 35, before the interchange of Route 66. Those are, one is a double static, and the last one is a single static. Then I have the same.
Can I just
Sure.
interrupt? Could you explain to the board what out front means?
Oh, sorry. That is the owner of the billboard. So it's out front outdoor advertising. That's their,
Okay. So it has nothing to do with front yard or anything
no,
like
it's,
that?
it's out front media.
Yeah,
That's
so
their.
that's why I wanted
I
that explained,
apologize.
so they would understand that.
Sure. And then I replicated the permits and the locations on the northbound side. I mean, I can surely go through all
No
of
need.
those, but
No need.
you know, that's the gist of the exhibit.
Okay. Do you
Just wanted
know-
to,
do you know how many of those existing billboards are on separate lots? They're the only thing on the lot, and the lot is otherwise vacant, or not?
Well, I do know a couple. On the northbound side, the two that are owned and operated by Outfront that are at 1549 Route 35, those are both on what appears to be the only structure on the property. On the southbound side, I believe 1519 Willow Drive, which is a double static, I believe that is also the only structure on the lot. That might be municipal property. 1126 New Jersey, Route 35 South, also constructed and operated by Outfront. That may also be the only structure on the property. And then as we get much further down, I believe the last two on the southbound side, also constructed and operated by Outfront. I believe those are the only structures on the property. I believe that is also municipal property. And on the northbound side, 1021 New Jersey Route 35 North, also operated by Outfront. That may be the only structure on the property itself. So yes, there are several.
and
Not a majority, but there are several.
What was the first one?
The first one,
It was on the south side, I believe.
I can give you the first one on the south side. 1519 Willow Drive.
Okay.
Mr. Boyd, do you know how the other, billboards compare in size to yours?
The sign faces are similar, 14 foot by 48.
I'm sorry, Claire?
No, right, there is no 1519.
5919.
5919. It's the third yellow dot from the left.
So all of the sign faces are similar to the sizes you're proposing?
The 14 by 48, yes, most of them are. Some may be. You may have a slightly smaller sign. They might be a 10-6-36, so 10 foot, 6 foot tall by 36 foot in width. So you may have a few mixed in on some of the older signs, especially some of those one-sided static. Sure.
Well, I still didn't find it.
Sure.
Yeah,
Okay.
It's the one underneath the one they're proposing now.
5919.
It's on the left.
Oh, you talked about that one, okay.
right, Willow
But
Drive.
you got two on 1549? Is there two there?
Yes, two right here.
Both?
They're same property. It's the same lot on the tax
Yeah,
map.
They're
they're the
separate.
same lot there.
Okay.
Yeah, yeah.
That's what confused me, thank you.
Yeah.
No problem.
I got it.
How do the heights compare? Overall height?
I don't have heights of all of the billboards. I did take a height of the billboard that's closer to our 922 site. So our 922 site directly across the constructed double multi-message at 1021. That one is at 33 feet above ground level. I did survey the height of that board. That's on the northbound side. The utility poles and wires are lower on that side of Route 35. all of our properties are on the southbound side. Our utility poles are considerably taller with much more utilities located on them.
Can you remind me again what height we're putting the one you're proposing?
This one is at a 45-foot height. That's from the base to the very top of the sign.
That was at a 28-foot pole, right? A 3-foot bottom, and then the sign was 45 feet, is that correct?
The sign height the face height is 14 feet in height.
What made up the 45? Where's that coming, where did I write
Yeah,
that?
but I think they're looking for the top of the sign.
Sure.
So-
If you
so-
go,
So go from bottom to top, Bill,
Well, thank you.
and explain
That's-
what the height is of
Okay,
the
thank
pole, the base of the sign, and the top of the sign.
sure, this is Exhibit A1. It's the site plan set that was submitted as part of the application. This shows a elevation of the proposed sign in relation to the existing building. So the ground elevation, from the ground elevation to the very top of the sign is 45 feet.
Then go from the base of the pole to the bottom of the sign.
That's the 28 feet. You also have a 3-foot apron that's below. So 17 feet makes up the sign face and the apron.
So 28, 3, and 14,
You
and
got it.
14 is the actual face.
That's correct.
Got it.
And the sign you compared it to was 33 to where? The bottom or the top?
The top.
Do we have distances between the existing signs? I'm looking at 1700 and 5919. Do we have a distance in feet between those two?
I put a scale on the plan down in the bottom right-hand corner. I can give it to you as
See it?
it's roughly 1 inch is 500 feet. Okay, so if you want me to measure off
I'll
any
do
of
the
them,
math.
I can certainly do that for you.
Mr. Matlick already
Just,
has it.
just for a
Got it
matter
already.
of clarification.
Oh, no, he doesn't have
I
his
see
ruler.
that there are 4 not constructed signs on the exhibit, and they're all IAAT permits. And one of those apparently is not before the board yet, is that correct, the northernmost one?
That's correct.
Okay.
So according to the plan, it's basically a Google Earth image, and it has the 500-foot scale at the bottom. I don't know how accurate that is because it's not really an engineered plan, but you know that's what the measurement is, and it looks like I would say it's about 1,000 feet, something like that.
Good eyeball.
According to that.
Get on, Ben.
So you have a reduced version of the exhibit. So it's actually going to be, I misspoke, it's going to be half an inch is 500 feet. So the full scale plan is 1 inch equals 500. You have a reduced scale, it's half the size. So half of an inch is, or 1 inch is 1,000 feet.
It's not to scale the plan
Sure.
that you're showing.
Yep.
So I can't tell you
Don't worry.
how
We're
accurate
not,
that
you know, you're on the hook. Don't worry.
That's probably pretty close.
And I think that we had asked for that at the last meeting. That's why I wanted to see if we had it. We wanted to know, in addition to the locations, we had requested distances between the existing signs
Sure.
as well.
So perhaps, Bill, just re-educate me distances that DOT requires minimum for multi-message and static billboards.
Sure. Between multi-message signs, so multi-message to multi-message on the same side of the roadway, 3,000 feet. From a multi-message to a static sign on the same side, 300 feet. If they're on the other side of this highway, doesn't count.
So the permits wouldn't have been issued unless we met that minimum standard.
That's correct. There's about a dozen standards that the board has to go through to meet. Distance being one of them.
What does that standard take into account? What's the reasoning behind the 3,000 feet as opposed to the 300 feet?
To the best of my knowledge, it's because the sign changes copy.
Mm-hmm.
Okay, so there's a different ad within every 8 seconds,
Okay.
where the statics do
So
not.
It doesn't deal with aesthetics, it just deals with the driver viewing the sign.
Correct, and our traffic engineer is here as well,
Yeah,
so
yeah, okay.
maybe he can better answer that question for you. But
Okay.
it's
Okay.
that, to my knowledge, that's what I believe it is.
Yeah, okay.
I have no further questions for Mr. Vogt, Mr. Chairman.
Okay. Anybody have any questions?
Just out of curiosity, what's that wind rated up to?
I'm sorry.
What's the wind rating on those signs?
The structural drawings will be presented to the building department, and all the wind loading calculations will be submitted to the building department. Signed and sealed structural engineer plans. I don't have that information off the top of my head, but it would certainly meet any standard, both by the state and federal level.
I have a question. I know this was discussed at the last meeting, but the board didn't have the wildfire lighting report at the last meeting. Can we just go back to that really quick? You have the chart that has the viewing angle and viewing distance, and then the number of foot candles at each distance. The ordinance, the lighting ordinance, says that the light spillage onto a residential lot can't be more than 0.06 foot candles, and it looks like that's around somewhere between 300 and 400 feet, according to the chart. Can you just point out where that is on the plan, just so the board can understand where that kind of cutoff is?
Sorry.
Okay, so
Between the sorry, you wanted to know the lighting level.
So what the ordinance requirement is 0.06 is the maximum amount of spillage onto a residential lot. So I want to,
Sure.
I would just like to see where that 0.06 foot candle is, and if it lands on a residential lot, or if it doesn't make it to a residential lot. So, like, I guess basically, does it comply with that section of the ordinance?
And you said it's 0.6 or 0.06?
0.06.
0.06. Okay, so at the 0 degree angle, which is the highest intensity, at 300 feet, I'm at 0.08.
Right.
So it's somewhere between 300 and 400. I drop down to 0.05.
And where does the 300 and 400 correlate to on the plan, where you have the arc?
Sure. The 300 would be the third arc, and the 400 would be the fourth arc.
And is that a residential property there, or is that still commercial?
If you if you go back to the cover sheet, that's Exhibit A1, our tax and zoning map show a 200-foot radius around the subject property. And then I believe the T1, the transitional office/residential zone, is directly outside of the C3. That would be on an angle. I would say I would meet that requirement because I am off angle from the 0 degree, so I'm going to be at, again, somewhere between 0 and 30. We're going to put in a light mitigation board where it only has a viewing angle up to 30 degrees in each direction. That was the video that I showed you last time. So again, we should be somewhere again at between the 300 and the 400. You can see that it drops down to 0.08 and 0.04 at the 20 degree mark.
Okay, so it looks like that lands on the Mavis Discount Tire property, which is obviously commercial.
Correct.
Okay, thanks.
Okay, so just for clarity, if you go over to the other picture, you have the degrees set up there. Can you show which line? Because it's kind of hard to read, at least from where I am. Zero.
Sure. So the board is shown in red, and then the first arc is 100 feet. The second one is 200. The third one is 300. The fourth is 400, and the last one, the fifth one, is the 500. And then we have the different viewing angles.
Yeah, the viewing angle is what I'm
You
interested
got so 0, 20, 40. Our 30 cutoff
Yeah.
would be here
Yeah,
in
so-
both directions.
Okay.
You mentioned something before about, I know we talked about this last time, the light levels at the ground. Can you explain what you said before about the light levels? At the
Sure.
ground?
So the lighting analysis that they do is a conservative approach. What they do is the billboard is the only object that's illuminated in the night sky. There's no ambient light. They reduce the output in the evening. It only operates at 3% output. Okay, so they measure the lighting as if it's a full white copy. So the whole board is lit up white, but at the reduced output amount, and then they take the light reading. They take it directly in front of the face of the sign. To be conservative, Watchfire takes that number, whatever it is, and uses the same number on the ground.
So 40 feet out
So-
from the sign would be the same as on the ground.
On
and
the
sign
ground,
is 40
which
feet out.
in theory it will be lower, but just for conservative approach, they keep it at the same light level for you.
It's like 40-foot candle or something.
And again, that's no ambient light, so if there's any lighting from the property or adjacent properties, roadways, that tends to wash out any or overpower any light emitted from the board. The purpose of the board is to display a message, not to illuminate the ground below.
Any other questions?
I just have one quick question, just for the sake of accuracy. It was stated earlier, maybe the attorney can answer this better than you can, that the sign, the third sign to be heard tonight, that's the one on Sunset and Route 35, was a static billboard. And the exhibit, I thought it was multi-message, and the exhibit here listed as multi-message. So I think that just needs clarification for
Are
the
you
sake
talking
of
about
accuracy.
922?
922, yes.
920. All of the IAAT permits,
Yes,
they're all for multi-message.
but there was a statement earlier that last one was going to be static. So I'm just trying to get that clarified.
The one that we're testifying that is going to be static is 1418.
1418.
It's the one in the middle.
Okay, and that also says multi-message.
Correct. Again, that states what the permit from the DOT
Okay,
has.
so,
We're
okay,
offering.
the application is also
Yeah.
for multi-message. That's what's confusing me.
100%.
I'm easily confused.
Let me get to that.
I think I could, when we get to it, but I'll
Okay.
represent that will be an application for a static building.
Okay.
No problem.
Why did they pick this location? What's specific about this location that made them choose to want to put a sign there?
I mean, I'm the engineer. I don't pick the locations. I engineer them for the app.
No problem.
But I'm hoping
Will there be
somebody-
anybody able to answer that, do you think, tonight?
Yeah, we'll bring up a representative, or the consultant on that. But, briefly stated is that, there's an analysis done of locations that would be suitable, and then to determine whether it would be approvable by the NJDOT. So you can have a great location, but it may not qualify under their standards.
Did they take into consideration the town's approval? I mean, you
That is, the town's approval is something that is required, but it's not part of the permit process.
can't
Well,
build
their
without
per-
town approval.
Their permit process.
Any other questions? Any members of the public with questions for this witness? Sure. We should get another microphone in here.
Another microphone that doesn't work.
Does this work? Okay.
Could you give
My
your
name's
name again and your
Diane Sarmont. I live at 192 Oakhurst Road. I know you talked about how many or how high the existing digital billboard is. I'm wondering if there are any other 45-foot high structures along Route 35.
I believe there are. I testify that the one sign that we do have measured, surveyed, is at 33 feet. There are other boards that appear to be higher than that existing beer.
I'm sorry, maybe I wasn't clear enough. Any structures, not specifically billboards. Are there any other structures
buildings
along Route
and whatnot?
35, buildings that are 45 feet high?
Most of the buildings along Route 35 are 1- and 2-story structures. I believe there are a handful of 3-story buildings. I believe the White Chart Realty building is a 3-story building. So yes, you may have
Okay.
a handful of structures that are close to the 45.
Would any of them be within the 25-foot setback?
I mean, that I wouldn't know.
Okay. My other question for you is, and it might be handy if I could see the Google Earth.
Sure.
My question is about trees. So when I drove by the site, or when I looked at it myself, can you just, I see it there, it's in
Sure.
red.
Yes,
So there's
the
a nice
property's
line
in
of
red.
trees there to the south side of the property, between that and Orchard, is that Orchard Street Plaza right below it? I think, the plaza,
to the
to
left?
the left of the
Yep.
red, of your property?
To the left.
Okay.
Yep.
So, flooding has been a big concern in Ocean Township. There's been flooding along Route 35. Do you anticipate that any of those trees will need to be removed?
No, we don't intend to remove any trees.
Okay. So the sign's up above the trees?
Correct.
So what happens when the trees grow?
Well, trees, if they interfere with the sign, they will be trimmed or pruned.
Okay. And I'm also curious about, last time you testified that you were going to be drilling a 4-foot wide and 24-foot deep hole for the stanchion, and I'm just wondering if there's any evidence of how that would impact the health of the adjacent trees.
It's a augured hole that gets drilled out, and basically the structural steel column slides in and it gets filled with concrete.
Okay.
It's very minimal disturbance. It's only in that diameter of the auger.
Okay, but we don't have any guarantee that it wouldn't cut the roots on the existing trees, damage those existing trees.
There's really that. I know on this photo there is a tree shown in the front. I don't believe that tree is there anymore. I think that's an older photo. This photo is, they're usually a few years behind.
Okay, that's all for this one. Thank you.
Thank you.
Any other questions from the public? Come on up. If you could just please tell us your name and your address.
Joan Dameray, 1633 Melville Street. How are you?
Good. How are you?
Good. I just have a question. For the permits, so I have the list of permits from DOT. That's the current list that they have on their website. Looks like there's 21 billboards currently in Route 35. For the permit for 1700, what's the permit number? Having trouble.
For 1700, it's 77495.
Okay, I have the right one. I just want to make sure I'm looking at the right
No problem.
information. Okay. So that particular location is directly across. There's another existing billboard, which you referenced. The state requirement doesn't matter how far apart they are.
If it's on the opposite, side of the roadway.
But Ocean Township's ordinance doesn't necessarily reference that. The other one is only 260 feet north of Talmadge Avenue, which is here, and the proposed billboard is here. So you have the other billboard that's already there identified?
Sure. What was the permit number?
So that one is just north of Talmadge on the northbound side?
Do you have the permit number or?
Yeah. That one is
Is it 77?
58174.
58174.
Yeah.
Sure. That's a double static.
Right, so that's directly across from the billboard on Route 35 that you're proposing. Almost identical, or just slightly off.
It would be to the north. It's probably
200 feet. According to the thing, it's 200 feet north of Talmadge. The one that you're proposing is directly.
The location,
Yeah.
the location of this sign is 200 feet.
Okay.
Is that? Are you reading the description on the DOT? Sure. Okay, so the DOT has a little map that goes along with the permit, and it shows the operator and whoever's looking at the permit an approximate distance of where the sign is from. It's usually a street. It could be a utility pole with a number on it. So that is probably what they're giving you.
Well, it's the permit list with the exact location of the sign. So my concern is, and to the board, is
No,
So
they're opposite.
This is not the time to testify.
Oh,
And you certainly will have opportunity.
Okay.
Now it's just questions as to his testimony.
okay, so not questions regarding Ocean's ordinance, because that was mentioned earlier that someone had asked how far apart they are with regard to Ocean Township
But
rules
they give you
versus.
facts.
Right, okay.
yeah, you could. So just so everybody knows, this is like a court where each witness gets asked questions.
That's fine.
And
So-
you could certainly ask him if he knows about the township ordinance, and Mr. Higgins may well chime in
Is
to
there
help
an
answer.
ordinance
So,
that applies to lighted billboards in general? Because the ordinance currently doesn't reflect that. Is that something you can answer?
I have a list of what is a comparison to billboard signs as a conditional use that are permitted in other zones. So what I listed on here was the max sign area, the max sign height, the width, and the distance to the top of the sign. Those are the that's the information that I found in the borough's code.
Okay. So I guess I'll wait till the later period, because I do have some other questions.
Higgins,
but
do you
they're
know?
not directly.
Their questions are fine, you can ask them.
Yeah, I'll just wait, because if it's not directly related to what he's speaking about, it's related to Ocean Township's ordinance. So should I wait?
Did you just give her permission to ask? You said her questions were fine, she could ask.
Well, that's, I don't know if the applicant's attorney wants to handle it now or what.
I'll wait. I don't wanna confuse
You
them.
have plenty of testemony, so maybe it'll be appropriate
Yeah,
at that time.
that's probably,
Okay.
yeah. it would
I don't
really be
want,
part
I
of
understand how the proceeding works, so I'll wait.
the plan. But, and technical things that you're asking, are available from this witness.
Right, I just wanted to make sure I was looking at the same, for this particular property, the same list that I was looking at, making sure it matched. My concern is, you know,
Yeah, yeah.
which is
Well, that's when we put you under oath.
not
and you
test,
tell us.
Yeah.
not a question, okay, thank you.
So,
Oh.
just to answer your question, I did note it on the plan, it's under the, so I'm looking at exhibit A3, it's the rendered version of the site plan, and underneath the billboard sign table, 8B, it says, no more than 12 foot by 50 foot of billboard advertising space may exist facing any one direction. There shall be at least 500 feet between any two such advertising locations. So that's where the 500 comes from.
Okay, and that's for Ocean Township,
That's correct.
okay. And so those two signs across from each other are more than 500 feet apart or less than 500 feet apart?
According to my map, they look at about 500 or more.
Okay, so that was my question, that they're right across from each other, but on the same highway, one northbound, one southbound.
Correct. I mean, they're not really that close to each other. They're, 1 inch on this map is 500 feet.
Okay. So I was just trying to clarify the distance between those two signs, between the proposed sign, and there's a sign that's already there that, I do not believe is lit up. That's a static sign on the other side of the street. We don't have any light. Sorry.
Sorry, I think
time's
that
up.
was me.
No, I'm just kidding.
That's me, I'm supposed to go so bad. Okay, so, and then the ordinance doesn't reference whether the sign is lighted or not? That was my question also. On your chart there. The rules about being lighted are there, what guideline are you following with regard to the sign being lit up as opposed to static, or multi-message as opposed to static?
So the standards that we follow are from the Outdoor Advertising Agency of America. That is
And
a
does NJDOT have requirements?
for the
Lighting,
lighting. They do.
And this meets obviously theirs?
Yes, this meets theirs, and it's this is industry standard that the signs dim like your smartphone or your dashboard in the nighttime hours.
But you have no guideline for Motion Township currently that you're trying to follow?
As was discussed before, it was just the illumination levels at certain distances when you're adjacent to residential properties.
And that comes from where?
Your ordinance.
Oh, okay, so the ordinance does articulate those.
Lighting in general.
Oh, lighting in general,
Just
not
lighting
lighting
just lighting in general.
directly related to a billboard.
Not that I see, but I can look around on the plan a little bit more. I don't really remember seeing anything in particular for the billboard.
I was just curious how you came to be able to make a presentation without guidelines from the township regarding a lighted sign, since I think there's only one currently in the township.
The guidelines that we're following is what every billboard and
Okay.
outdoor advertising
Gotcha.
sign follows. So some municipalities have a updated ordinance for billboards. There are a few out there, but they're few and far between.
Okay, I appreciate your clarification.
No problem.
Thank you.
It's going to be on the New Jersey Turnpike versus two-lane highway, state highway. Or are they
It
the
has
same?
to front on a highway, and there are certain requirements for it.
But the guidelines, are they different? So would you agree Route 35 in Ocean Township is different than, say, I-95 or 195?
I'll tell you what, our traffic engineer is here.
Yeah.
He can definitely better explain that to you. There's different classifications of highways,
Mm-hmm.
and
Are
from my
there
understanding,
different
goes to that
classifications
effect.
of signs to match those highways? Is that something you can
Not
answer?
to my knowledge.
Okay.
The signs are
Sign to
just
sign.
different sizes.
Yep. Okay. Any more questions from the public? Okay.
All right, Mr. Chairman, our next witness is Brian
Thank you.
Intindola, our
Thank you.
traffic consultant.
I'm sorry, can you repeat his name?
Intindola, Intindola.
Mr. Intindola, can you raise your hand? Do you swear the testimony you're about to give is the truth and the whole truth?
I do.
Can you give us your background?
Yes, my name is Brian Intindola. The spelling of my last name is I-N-T-I-N-D-O-L-A. I'm a licensed professional engineer in the state of New Jersey. My license is current. My career has been mostly on municipal scale traffic engineering, either on that side of the table or on this side of the table. And I'm appointed in North Jersey to, I think, 77 boards or so in that capacity, as well as doing private applications such as this. In terms of the towns I've been in front of, I think the count in New Jersey, I think, is about 220 separate boards and or zoning boards.
Great, thank you.
What happens when you get old?
I am old, so it doesn't matter.
Brian, what were you retained to do on behalf of IAAT Services with respect to the proposed billboard?
So, I get paid for my professional curiosity, so the applicant wanted to present to the board, what are the traffic impacts that are known for a variable message board or an LED board in this instance, or a multi-message board, which we're presenting, and then convey to look at the research and based on my own experience as a traffic engineer, and relate that to the board to talk about safety concerns for if it were to be constructed. So that was basically my charge.
Okay. And what did you do in order to reach an opinion?
Well, first we looked at the Mr. Voigt's plans that he submitted to the NJDOT as well as to this board. And then we looked at the traffic characteristics of Route 35 in particular, and at 1700 Route 35 southbound specifically. And then we also looked at the NJDE NJDOT permit process that they have established, which has its roots from the Johnson administration to try and beautify or at least control billboards in the state of Texas. And that went on to federal legislation. If you take federal money for your highways, you have to have a billboard process. So that's what brings this process. And New Jersey has taken it further. I'll just give you a background of why we're here. And New Jersey has taken that permit process further, that this board has to review it before they can move forward into construction as part of that process. So that's part of what we do to understand the context why we're here. And Mr. Boyd has discussed the attributes, the luminosity of the board, how it dims at night, and then I would just strengthen that testimony that based on my research and with an 8-second hold on the sign, we don't see a correlation between traffic, between crashes and billboard construction. And we looked to see if that was the case, if that drives distraction in a particular corridor. We haven't seen it, and based on the NJDOT process, I believe they have not seen it that way happen as well, because with the 8-second read, that goes way back to computer architecture of bits and bytes. To make a character, it takes 8 bits to make a byte, and that goes back to how it was perceived that the human brain processes information. So that's why you're on a 64-second minute, because 8 times 8 is 64. That all goes back to early computer architecture, which goes back to how the early computers, analog to digital, worked, and that's how that's how, when that was translated into billboard reads, the 8-second read gives the message. It gives time to read the message, and that is in the context of minimum distraction. And it seems that that 8-second read works. And this particular sign, I believe it's like 30 foot to the bottom with the 14-foot height. And the way it's situated is that it gives a good read for the southbound 35 traffic, that it takes advantage of that 8-second read, so it is not a distraction. And the cone of vision to read it from the eye level, from the driver's eye level to the sign, is where the read should be. And then when you get underneath the sign, it doesn't distract you from making turning movements at the local intersections and the driveways. So, we can say to the board that based on the data that's available, we have not discovered any studies that indicate that an increase in driver distraction has caused accidents due to billboard construction, either static and or variable message signs. And that is why when you take it to the NJDOT process, they look at that, and it's not really a question of distraction in the DOT process, because if it was a distractive or an impediment to traffic, they wouldn't be permitted, right? You wouldn't put that on the road. So really, it's a question of, spacing and following, the rules that NJDOT has promulgated over time that works for New Jersey and for, the access level highways that we have. So one of the questions that one of the board members had, is it comparative to the Turnpike and Route 35? No, they're different highways. They're limited access highways. I believe that the Turnpike has its own billboard process that is not in the AOS process, in the NJDOT process. But the NJDOT process is fairly laid out. It's like a variable message, space, then another variable, not variable static, space. It's pretty well laid out. And those distances are built in for the read, to read it without being distracted. So the safety is built into the read of the distance based on the board that's being presented. So I think that's basically what I could present to the board. And it's, you know, there's the nuts and bolts of the buffering for the stanchion. Is it safe? It should be protected. Things of that nature that the board will consider. And the NJDOT also considers that there's enough space between the curb lane or whatever lane to the billboard column or stanchion. So we haven't seen any indication that it's a detriment to the motoring public, and I think that's what we wanted to convey to the board tonight.
Just a few follow-ups, and we'll deal with the specifics first. The top of this sign is at 45 feet from it.
Correct.
You believe that's appropriate under the circumstances based upon the location?
Yes, I mean, you know, I am the applicant's traffic engineer. You want to get the read that is maximized for that Route 35 corridor, and that height gives you your maximum read without being a distraction, but as well as hitting the sweet spot where you don't have to look up too far when you're doing your read, and then you get the message. You're at the comfortable cone of vision of 20 degrees, which is a commonly held cone of vision to read things comfortably while you're driving, whether it's a traffic light or whether it's a billboard. And so, the height is a function of maximizing the read, which I think we've done here.
Then, going in more general, the chairman's question, he used turnpike as opposed to the 2 lanes for Route 35.
Mhm.
Is there a distinction if there is a 2-lane highway, a 3-lane highway, or a 4-lane highway?
If in the NJDOT process, the turnpike, I believe, has their own process for billboards, and I think their spacing's a little bit different. But overall, globally, aside from the turnpike example, if it's an access level 3 or above, meaning it's you can have a billboard permitted. That's one of the things that the DOT looks at. And the access levels are determined by what you need to do if you were to build. How they do it is that the access levels are a function of how much throughput the state wants to go through, as well as manage safety for access points. That's how they come to that the access level.
So would that result in a distinction based upon the number of lanes on the roadway, or that's?
Well, right. You have, so some access levels are 2-lane or 2 and 2, 4 total. Some are 1 and 1, and some are 3 or 3. All of them, like say, Route 35 is comparable to Route 46, Route 3, 66, 18. So it's in that comparable types of highways in this area.
So it's not the number of lanes, it's the type of access that DOT designates.
Correct.
Okay. And I believe you may have spoken about this quickly in the beginning, but the multi-message board will not have any significant impact with regard to the traveling public, correct?
Other than conveying the message, we don't see a significant impact.
Right. And you've indicated that based upon your analysis and experience, that there is nothing that you have seen which would indicate that a multi-message billboard would impact safety based upon crash data that may or may not be available.
Right, so yes, and to answer that question, what we look to see is that, like for the Route 35 corridor, we have available to us a state police database, which is called Safety Voyager, and then you correlate that to positions of multi-message signs, and for me, I check this once in a while out of my own personal curiosity. Is there a correlation between a variable message LED sign billboard and a location that would indicate that there's a higher accident rate than everything else being the same? And I don't see it. I see it where you expect it, at like an interchange or a traffic light, or where like 2 highways would merge. That's where I would see those hot spots. But there isn't like a hot spot in the middle of nowhere just because there's a billboard there. I haven't seen that correlation.
Right. And one last question. One of the members of the public had questions about either side of the roadway. Could you address that briefly, rather than me testify that one is up, one is on a different side of the roadway, I guess it would have to deal with distraction to the public.
Well, that's the way the DOT does is that it's direction blind, so to speak. Northbound has their permit distance. In this instance, southbound has their permit distance. If they're across from each other, that's not taken into account because, as we've said, the distance is a function of distraction for the movement that you're going in. And so if you have a double read message board, you may be seeing the southbound board at the northbound side and vice versa, but the DOT process hasn't discerned a safety concern with their approach.
All right, I have no further questions for Mr. Intandola.
Jim, our ordinances don't take into or do take into account north or which direction you're going, right?
They
So
don't take into account which direction. No.
So let me say it a different way.
Are you asking about
So
proximity?
the New Jersey Department of Transportation does not care when it's on the opposite side of the road. We do care in Ocean Township.
They look at what they think is the minimum safety situation, as I understand. And here's where I have a concern. I'd like to ask questions, but I don't know enough about what this gentleman is talking about to ask an intelligent question. And I'm sitting here thinking, and the applicant's attorney can throw something at me if he wants to, but I'm thinking the board really needs to get a traffic expert in here to ask the questions, to analyze the testimony, and make the board understand what it is this gentleman is actually saying. Now, the DOT doesn't care about aesthetics, they don't care about light air and open space, they don't care about economies of scale in terms of the structures and so on. They're basically focused on traffic safety.
Yeah.
So
You had a question at the last hearing about how long the sign would be visible as you're traveling along the highway. I don't think it was answered, right? Did anybody come up with an answer? Do you have any idea?
I think that, from my view, I think it was about, to the next intersection, I think it was about 500 feet or so.
No, but time-wise,
So time.
as you're driving.
So if you're doing about 48 miles an hour, right?
Mhm.
That's about 840 feet in 12 seconds. So we have more than enough distance, in an 8-second cycle to see that. I don't know if that answers your question.
they're not going to see all 8 cycles by any means.
Right.
Right.
But how many will you see?
A cycle in maybe a cycle and a quarter. And that goes to the 8-second read.
Okay, so if you're traveling southbound and you're just crossed over West Park Avenue, for about 12 seconds, you'll have this proposed site in your sights, and on the left-hand side of the road, you'll see 58174 at the same time, right? And then presumably you'll also then see the next one on the left-hand side of the road, and then the one that's by the green leaf. Okay.
So if
Yeah. So you see from both sides of the road.
not that I want to volunteer any information, but if Mr. Higgins has any questions I can clarify, because it's all pretty straightforward on the read and the distance. And if there isn't, I apologize that I didn't convey the information that I needed to.
I just don't understand enough about it to ask intelligent questions. That's my concern.
We'll start with unintelligent questions and see if we get some answers.
So you may have a traffic engineer?
Yes, we have traffic engineers. I'm not a traffic engineer myself, but I'll say that I've heard billboard applications before, and the testimony provided is very consistent with other traffic testimony I've heard regarding multi-message billboards. I don't particularly have any specific questions, but if Jim has something that he'd like more information on, that's fine.
Does anybody have questions to ask now?
I guess I have more than it's kind of a comment more than a
question, and I guess you can respond to it, but the area where we're putting this sign on Route 35, where you're trying to put the sign, there's an in and out of parking lots and shopping centers every 10, 20 feet. To say, I just can't imagine driving down a road and looking up even for a second to look at the sign, how that's not a distraction, how somebody could say that's not a distraction. A bird flying across my windshield is a distraction. So to say that I'm driving down the road and looking up at a sign and that's not a distraction, I don't know how that anybody can say that. It's a distraction. How big of a distraction? I'm not here to say that, but
Right,
it's definitely a distraction.
I mean, I'll take a stab at responding to the comment. In the global definition of distraction, that's all relative to the person, right? Some people are easily distracted, some people are not, some people are hyper-focused. But the 8-second read has been studied for a long time by the Federal Highway Authority when they were going through the process of the LED, the initial research papers for variable message billboards and the 8 seconds. The 8 seconds are based on, you know, reading how many bits of information can you process to get off the highway to say to take the split for the parkway, express, not express. That's all been, this 8 seconds is born of that research. And that 8 seconds is what the years of research state that 8-second read is a solid read that doesn't promote distraction to the point of safety for the bell curve of people's bandwidth of being distracted.
And I would argue that we're not a highway like the New Jersey Turnpike or the Parkway.
No, I'm just.
Well, yes,
There's a
use
divide.
Route 18 or
Correct.
195.
Right,
or
or even
state.
Hold on, let me finish. But my point is, you have people pulling in and off this highway every 10 or 15 feet. So the fact that you're looking at this sign even for a second is cause of concern for an accident to happen.
And rightly so, but I believe that 8-second read takes that into account to minimize distraction and maximize the read. There's a, like anything in design, there's a reasonable balance point, and that 8 seconds is, after years of research, where it has arrived at.
But the 8-second read doesn't take into account the height of the structure, the size of the structure, the fact that it's located in the front yard. And that's, all those things are things that I have concerns about, particularly since the ordinance was set up to have the maximum 25-foot height and not allow the structure to be in the required front yard. And those issues were concerned when the ordinance was being developed. And so that's where I just don't know enough about all of that to advise the board, and I don't know if Ben does or not. It's something that I'm uncomfortable discussing.
So when was your ordinance first born?
I believe it was 1992.
Right, and was there any prior iterations of that were carried forward?
No.
And you have a maximum of 25 foot on the height?
Yes.
It seems a little low generally, but
Well,
it might be that
See,
that's what's comfortable for Ocean Township.
yeah, and that's one of the issues before the board is the height, the location in the front yard, as well as numerous other conditional use requirements that need to be met.
Right.
And those are the variances. And that's why I think if the board had its own traffic expert to come in and look and work with you to see, what's reasonable and so on, I think that would be a better solution. I'd be much more comfortable with that.
Well, I respect your professional opinion, but I think we made a pretty clear record, based on
Okay.
the NJDOT data and our
Yeah.
experience. Thank you.
Was there a traffic report submitted?
Yeah, we wrote, there was a traffic letter submitted with the
It was
application.
submitted with the application, it was dated, March 6th, 22.
Yeah, I think it made it into the file.
Anybody else have questions while we look for the traffic letter? Do any members of the public have questions for this witness only? Okay.
We have one of this, we have a traffic report of December 19th, 23. Is it been an update?
That's the updated one, and I believe I sent that in.
No, that's the one the board has.
Right,
This one's dated March 6th.
right. That was the one that was sent in probably after the application was filed by Mr. Christian. And then I submitted the
And
revised.
we have one of March 6th, 24.
Right.
We have two.
This is the March 6th one that we're testifying to.
Towards the end of the package.
Hi, my
Okay.
name is Marianne Illis. I live at 1308 Garvin Avenue.
Miss Illis?
Yes.
Okay.
ILLES. So if I understand what you're saying, there's no difference in the processing time for a driver, whether the billboard, sorry. It's, I mean, I'm just thinking common sense wise, if you're dealing with the traffic situation on West Park Avenue or Sunset Avenue, that there has to be a difference in processing time and attention between that situation and a turnpike where the billboard is in a distance. Does the board have the data that is going to support this?
The data is, well, the data is years of research. It's available publicly.
Okay.
I don't want to bring volumes of data.
Could you
but,
direct me to something that would
if you
clarify
look at
that?
if you look at the FHWA research in billboards, and a keyword would be 8-second hold for billboards or outdoor advertising, and the number of BYTES bytes the human brain can process comfortably, get a message in a flow of time. That's basically the keywords that you would look for if you want to do independent research. It's all available online or publicly available. I'm not making any new ground here. It's based on solid research. And so I think you had a question though, that the difference between the two, like a local street and the highway and the turnpike. But what we do know is that the 8-second hold seems to be a reasonable amount of time for a billboard to hold and minimize distraction to the point that it doesn't impact safety.
Even in a condition where there are driveways and intersections,
Because right,
interchanges
so at
and-
one point, right, you'll be focused on the turning movement, and you're very rare that I look at a billboard and say, "Wow, that's very compelling," and I don't. I look away from the driving task at hand, and that's part of what the 8-second hold is. And then, as you come to the decision point for the read becomes uncomfortable, and you're out of the cone of vision to execute whatever turn you need to make, because you're not looking through your sunroof to make the right turn off of Route 35 southbound. You're looking forward where you need to have your eyes on the road.
So the data that you mentioned, it includes all types of traffic situations.
Well, if you get through enough data, yes. You know that.
What do you mean by that?
What I mean by that, that the original research for variable message signs looks to, and as adopted by the NJDOT, like the ultimate imprimatur that I have to work under is what the NJDOT says. Whether it's for curbs, sidewalks, handicap ramps, striping, signage, all that. And ultimately, how long can a billboard present one face? It's an 8-second read. 8 times 8 is the 64 is the flip, as Mr. Boyd had said. So that is, you know, at some points I question it, but to me it seems that when I looked at where there are billboards in the middle of nowhere without any intersections, I don't see any appreciable increases in the crash rate, which is available on Safety Voyager, which is a traffic tool that I use.
Can I just ask, I'm trying to clarify, you keep going back
over here. You keep going back to the 8-second read. Is your testimony that the 8-second read is or the 8-second change is an appropriate time? It's not too fast, it's not too slow to cause a distraction. Or is your testimony that any billboard on a street doesn't cause a distraction?
I would say specific to the multi-message billboard, it's important to put it in the context of the 8-second read. And the 8-second read does not cause a distraction that impacts safety.
Okay, but we can't say, or you can't say, that any billboard onto a street, to my colleague's point, wouldn't necessarily cause a distraction.
I think I answered saying that some people are easily distractible, right?
Okay.
So like if you drive in an area where there's no billboards and there's no distractions, and you're so distracted that you can't drive, then you shouldn't drive, right? You have some sort of condition. But if you're in the bell curve of human experience, which most reasonable engineering assumptions are made, then that doesn't cause a distraction for the typical driver.
Okay, but logic would suggest that if you are traveling down a street that has multiple driveways and there is a new, very large sign that wasn't there before, that is a new, potentially added distraction. And there's really no data that can prove that wrong. It's just that maybe some people aren't distracted by it, some people are.
But you're working from the assumption that it's a negative impact in the introduction of the sign. We're saying that there is no evidence to say that a billboard causes accidents.
So you can't prove it wrong, but you also can't prove it right.
But that's really going down a logic rabbit hole that, and that's fine too. We can do theorems and all that all night. But
exactly what I was trying to get to.
But I can't rely on that as an engineer.
Fair
what
enough.
I can rely on is empirical data and not logical arguments. I have to rely on, my livelihood is empirical data.
Speaking of data, so do you have a copy of the survey? Because the logic, to me, sounds that 8 seconds and the billboard flipping every 8 seconds has more to do with advertising revenue and what the human brain can process it during one pass. Because that's the advantage of the multi-message billboard, is how many ads can the person see. I'd like to see the study. I keep hearing about this study, but I don't see anything.
No, it's the aggregate body of information that I've read over years. When I design a street, you cannot put too many words on a sign because you can't process it, right? The same with the 8-second hold. If it was revenue based and not safety based, then they would push it to.
So why not 15 seconds?
It could be, but then it's.
But would you want to do? I bet your client wouldn't want to do a 15-second rotation.
But that is not the law. That is not the regulation. Like I said, the ultimate.
Like I said, I'd like to see the study because the state police, when I got a ticket for looking at my cell phone pulling an 18, that they viewed my distraction a little different than the 8 seconds.
Well, the data is available. The accident data is available from your local police. You can put the Oprah request in, or you can use Safety Voyager. The data
I'm not
is
the one
readily
asking
available.
for the permit. You are, so.
No, I'm just saying it's widely available.
Yeah, but why isn't it here?
Well, we wrote the report, and then there was no question about the
But you
report.
keep citing a study that.
Okay.
I mean, right now it's hearsay.
It is not hearsay.
Well, it is. You don't have this.
There's a report that I submitted.
He has a written report.
No, but does it have the study in it?
Based on he's an expert in the field. That's based upon his knowledge and his research and his expertise. If you're questioning that, and
Yeah, I'm questioning your report.
He is paid by the applicant to testify. And if you're questioning that, we could require somebody from our.
It's required.
Right. We'll leave that to the planners to vet
Yeah.
that my testimony supported that.
If again, we have the availability to ask our engineering department to review the testimony and give us their opinion. Now, it may be the same, but if the board feels more comfortable with that, it's doable, right? Right.
Can we arrange that to educate us?
Then I'd like to propose that we do that.
Yeah,
Why don't we get through testimony and see where we go? Maybe we won't need
We're
it.
still on number 1 here.
Yeah.
We're on number 2.
Yeah.
Sorry.
We got 1 more to go. Right? 3, 4? I thought it was 3. You added 1?
Witnesses?
Yeah, witnesses.
We have one more witness, Mr.
Oh,
Chair.
yeah,
We
no.
have a
I just,
planner who's
yeah,
very
well, let's-
important testimony.
let the applicant get through his case, right? We'll discuss
Yeah.
where we're at, and if we need,
There may, I don't know, did we finish with the public on this witness?
no, I'm
Okay.
trying. Did you have any more questions? We rudely chased you away, and I apologize. Okay. Come on up.
I wasn't here to ask questions from you, but now I am.
Just repeat your
If you,
name.
yep, say your name.
Joan Desmarais, 1633 Melville Street. So, the LED sign, which is what we're talking about here, not a static sign, the LED sign that changes every 8 seconds, that came into effect around 2005. When were LED signs first?
General practice, we started installing them about, the technology was reliable about then.
And when would they be generally widely used?
In the last, I'd say, about 10 years or so.
So the
we've-
studies you're referring to reference only a 10-year span
That
with
is
regard
not,
to the
that is not
8-second
what I,
rule?
that is not what I said.
Well, a static sign that's not moving wouldn't have the same characteristics for an 8-second situation.
The general research was done to see if you can process so much information, at what point that becomes a distraction. And of course, once that empirical data was established, then there was other studies that supplemented the LED billboards that are now
But
becoming more prevalent.
it's the attention span studies that you're referring to, the 8 seconds where the bites, all that part in the beginning, that part of your testimony isn't necessarily directly related to billboard lighting or watching the ads go by until at least 10 years ago.
Yeah, I don't know the question.
You're referencing over years of study and your expertise that you've studied the 8-second rule, meaning that that's the amount of information someone can sort of ascertain when they're looking at a moving billboard. The 8-second rule is the safe amount of time that I won't be distracted while driving.
Yes.
We've only had the LED billboards for like a decade. So the testimony is only really directly related to the LED billboard safety over the period of time that those boards have even been in use. I understand prior to that, there's studies that can say, how long can I focus on that light bulb until it changes color or something like that. But you have to acknowledge that we've only had the billboards for 10 years, so how much body of evidence could be there when we've only been having them for 10 years?
Well, ultimately, I have to rely on what the state of New Jersey has done, and they have staff that researches beyond what is available to me, and they feel also that the 8 seconds is, you know, the balance of reading the message and driving at the same time.
And their 8-second rule was established when LED boards became available for general use, or when were those rules written?
Those are generally the rules. I don't know the exact time. When the AOS changed their laws to account for LED signs, but I think it's in the last 15 or 20 years. I don't have the exact statutory change when they brought that in, but that is the rule that has been in effect.
So the statutory rule was based on static signs then?
No, it was. Let me finish. It has been modified clearly for LED message signs.
And that was when?
I do not know.
Okay, because that would be the key thing, that when did New Jersey decide the 8-second rule was the safe thing when it comes to LED signs? Just curious, because the body of work you referenced, it sounded like we've been, you know, it's been a 30-year thing, but really LED signs have only been in use for 10 years. So there's really not a significant amount of body of evidence that would show whether it was safe or not. That's just my opinion, but I'm not allowed to provide testimony, I'm just asking.
Not yet, not yet.
I'm all done.
Just to follow up on that question here. The NJDOT files. Do they follow the federal guidelines? Is it to a T?
Pretty much. Sometimes the NJDOT is more stringent because of their experience, like with respect to other aspects, and I think they are on point with what the federal guidelines are for the 8 seconds.
And do you know if over the years, I won't hold you to the year or anything like that, but was there one requirement that then got changed to 8? Like, did it start out at 5, or maybe there was no rule at all, and they said, "Oh, geez, we got to make something."
Based on my understanding,
yeah,
because the body of research said the 8 second is a good read for any sign.
Mm-hmm.
You know, that is important, and I think they just carried forward the 8 seconds immediately.
Okay.
It was never 4, 5, 6. Oh, we've got to tweak it. Come up to 8, or you know, it's always been 8.
Yep. Okay. Thank you.
That's
Hello, sir.
My
Did I take
name's,
your question?
yes.
I'm sorry.
My name's Elliot
You could ask it
Catan.
again.
I live at 28 Old Farm Road in Oakhurst. That was practically my same question. That I'm sure over the last 15 or 20 years they reviewed that 8 second view, and it has not been changed. Correct?
Well, no, that is not the case. The way state law functions is that there's a reauthorization every 5 years of any state statute. And in that 5 years period, right, every 5-year cycle, most laws, especially access laws and AOS laws, are the legislative body will ask the subject matter experts of the NJDOT to weigh in on any changes that they would want, and in doing that, they also go out and seek public comment on those particular changes. So every 5 years, there's an update to reflect the science of and the experience of whatever law it is. So it's not a 30-year law that's been static since they figured it out.
Exactly. So
it's updated every 5 years.
So that means it works. That means that 8 second rule works.
As far as I know, if you were looking to see that,
Because if it didn't work, it would have been changed.
right? As far as that, you could make that connection, but I don't know if that was specifically done. But you would think that if there was a problem with the 8 seconds, it would change over the 5-year reauthorizations of every
Correct.
law.
So the 8 second works. Thank you.
Any other questions from the public? Okay.
I have 2 minutes, Mr. Chairman. I just want to see if I'm having 1 or 2 witnesses.
Sure. Okay.
Thank you for your time.
Thank you very much.
Appreciate it.
Thank you.
Go ahead, it's too hard. You have 8 seconds.
Down to 1, Mr. Chairman.
Down to 1. Okay.
Andy, you're next.
The sole function of this structure is to take your eyes off the road 100%.
Okay. Can we gather again? Can you take a roll, Claire, again to show that we're all here?
Vice Chair Fuller?
Yes, here.
Whitman? Here. Mr. Muzzy?
Here.
Mr. Morrow?
Here.
Mr. Nero?
Still here.
Puglielli?
Here.
Lineski?
Yep, still here.
Here.
Our next witness, Mr. Chairman, will be Andy Schaefer, our professional planner.
Mr. Schaefer, could you raise your right hand?
can.
Do you swear or affirm that the testimony you're going to give will be the truth and the whole truth?
Yes, I do.
Okay. Could you give us an idea of your background?
Sure. My office is in Mays Landing. I've been a professional engineer for 40 years now and a professional planner in the state of New Jersey for 36 years. I don't venture this far north very often, so it's mostly Cape May and Atlantic County. And as my colleagues were discussing, it's so busy right now, don't even come to Ocean County anymore for the most part. So
I'm familiar with Mr. Schaefer, and he's qualified planner.
It's cold up this north, right?
yeah, there you go. It is.
I came the other direction from Oakland.
Okay.
Andy, what were you retained to do on behalf of IAAT Services with respect to this application?
I was retained to look at the special reasons, detriments, and benefits under NGAC 40:55D. and how they apply or not to this particular project for a billboard at 1700 State Route 35.
Okay. And in that regard, what did you review prior to coming here today to testify?
Okay, the submission material. So I did not do any investigation on myself. This will be a conglomerate or gathering together all the other testimony together and feeding that into the special reasons and how they apply, as well as all the exhibits and site plan and so forth. I reviewed that, and I spent an enormous amount of time on Google Maps myself, because I want to have some firsthand knowledge here of what's going on, as to the frequency, the distance, the type of neighborhood it's in. But it is a very busy neighborhood with lots of driveways. All the stuff we've heard, both from the public and the professionals, has been true. It's a very busy place. We discussed during the break, the 8-second flow of time for a sign. You're lucky if you pick up half a second of that because you're busy doing other things. But they still leave an impression, if you will, and sometimes you may have to see it twice the next time you're on the road. But I don't think we would want to imply that people are expected to read that sign for 8 seconds. The messages are much simpler than that, so you don't have to. You can glance at it while you're managing yourself in heavy traffic.
Okay. And specifically, what variances would be required for this application?
All right. First of all, we'll need a D1 variance to allow one multiple uses, with the collision repair and the billboard being on the same lot, not a separate lot, and then the billboard use in general. So your ordinance section 21-5117 starts out by saying the construction of a new billboard shall not be permitted in the Township of Ocean. There isn't a place that I could find that they are permitted other than rebuilding or replacing one that already exists. So that's the basis of the D1. And then a D6 variance for the height, because it appears with this, at the setback, 35 feet may be permitted at 25 feet, but we're asking for 45, which triggers a D6 variance for the 10% or more than the permitted.
You're asking for 45, is that what you said?
I'm sorry?
You're asking for 45.
45 feet, yes. So it's more than 10, it's 10 feet or
More than
greater.
10%,
Yeah,
I
more than
thought you said
10%.
25.
All right.
Sorry.
So let's just focus on each of those variances. The first is to allow for more than one use on the lot, correct?
That's correct.
Now, this is, on the lot is the existing collision center, and then we're proposing to add the billboard.
That's correct. So we are adding a billboard to an existing use that's been existing for some time. And this will not impact the existing parking lot or pedestrian ways, and it will not generate parking requirements of its own. So the impact on the site will be minimal, if anything, except for a visual impression of having a sign where one didn't used to be.
And in addition, you indicated that a D6 height variance would be required because we are requesting 45 feet.
We're requesting 45 feet for the 14-foot high sign itself with the 45 feet. And that again is being, to repeat some of the previous testimony, that is being done to provide a view corridor to the sign through the wires that are pretty heavy on that side of the road, of Route 35.
It's my understanding with a D6 variance that it is one of site accommodation.
Correct, and this is accommodating the site so you're looking at the sign, not looking at the, trying to look at the sign through the wires. And I was reminded of that earlier tonight. I missed a green arrow because there was a wire going straight through it. I got honked at.
Okay. What other variances are required?
Well, we need a front setback variance, which is a C2 because it's something we're self-creating for the 25-foot front setback.
And what is the setback required in that zone?
25 feet. I'm sorry. For something this high, it'd be 150 feet, I believe.
Right. And we're proposing to put the sign back 25 feet.
That's correct.
Okay. And what other variances besides?
That should be it.
Okay. So, in that regard, with respect to, let's focus on the D variances, D1. What reasons exist for the granting of that D1 variance?
And again, we are in a fairly crowded neighborhood, and under 40:55D, item A, to encourage, I'll just read that to you, then I'll go into my testimony, to encourage municipal action to guide the appropriate use or development of all lands in the state in a manner which promotes the public health, safety, morals, and general welfare. This site is particularly well suited due to its distance far enough away from residential that we will be producing less than 0.06 foot candles at the nearest residence. And that its site is located on an arterial road with existing commercial development that includes numerous signage, including 4 existing billboards just in the immediate neighborhood. And it's a commercial and retail service oriented area, so this fits with the characteristics of this type of neighborhood, as well as the signage and the busyness, if you will, of being a commercial district of high intense use. Under item D, to ensure that the development of individual municipalities does not conflict with the development and general welfare of neighboring municipalities, the county, and in this case the state in particular, because we do have a state permit from DOT already, who in their opinion has deemed this an appropriate location for the sign. Because we have obtained that NJ DOT permit. Then under item F, to encourage the appropriate and efficient expenditure of public funds by coordination of public development with the land use policies. Well, how does that fit in? And that this is what we're offering is, since it's a multi-function sign, is to make it available to the municipality for municipal access for emergency and public safety alerts. And that we would have to create a way that that would be done in a quick situation, an Amber Alert, whatever, that so you would be able to have access into that sign as the municipality.
And with regard to that access, that's something that's typical for these multi-message billboards.
Correct. And just the technicalities of working out that access would have to be done.
So it would serve a public purpose also.
It clearly serves a public purpose, yes. And then under item G, to provide sufficient space and appropriate locations for a variety of agricultural, residential, recreational, commercial, and industrial uses, and open space, both public and private, according to the respective environments, in order to meet the needs of all New Jersey citizens. And under this one, the site is particularly well suited, again, because of its distance from the residential, and that the road is already an existing commercial development that includes numerous large billboards and retail-oriented characteristics and a lot of traffic. This is the commercial zone. Additionally, with this sign is proposed to be on an arterial road with significant commercial presence, it will benefit the residents and tourists and local businesses by presenting the information of what is available there. And lastly, as I also repeated, there'll be public access to the sign for public messages. Now,
what about the negatives, Mr. Schaefer? How do we get over those negatives in terms of the number of uses, the height, and the front yard setback?
And again, the front yard setback is because we don't have room for it in any other place, as well as the height. Again, is positioning the sign to be viewed through the wires as you're coming down the travel lanes, without having to, as was mentioned earlier, look through the sunroof. So,
and it would be typical that a sign would be located closer to the roadway, not farther away for
that's
visibility.
Correct. That's correct.
All right. With regard to the negative criteria then, Mr. Schaefer, let's please continue.
I wasn't able to find any particularly negative impact associated with this. Again, we've made access for pedestrians underneath it. As far as the sidewalks, we're not blocking that. We're not creating any blockages in the parking lot or driveway. And its negative impact is mitigated by the fact that it's in the middle of a busy commercial zone.
Okay. And when we look at the negative criteria, there are the two parts to that. One is that would there be a substantial detriment to the surrounding area, surrounding neighborhood? You would agree that there would not be a substantial detriment?
That's correct. I agree there's not a substantial impact to the neighborhood.
Right. And then in addition, there is the secondary, the impact on the master plan or the zoning ordinance of the municipality, in this case the Township of Ocean. do you believe that there would be an impact on either the master plan or zoning ordinance?
No, I do not. And again, that's why we're here, because we're proposing something that's custom and doesn't fit within the confines of the ordinance to be an effective sign.
Now, I believe when I read Mr. Higgins' report and listened to some of his questions, he was referencing the existing ordinance, which I believe we learned was in 1992, but that ordinance only would permit what is existing to be rebuilt, is
That's
my-
correct.
Okay. But those standards in the ordinance, we would exceed anyway. I believe that ordinance had a maximum 25
It
feet
had a
high.
maximum height of
And
25,
like-
yes.
And in this instance, we're asking for the use and not the deviation from the conditional use.
That's correct.
Okay. I have no further questions for Mr. Schaefer.
Anybody have any questions for Mr. Schaefer? Jim?
I have some questions and some comments, and I can understand why you think that's a D1 variance for the use of the billboard. But you have to look at the construction of the ordinance and the intent of the ordinance, and the wording, quite frankly, is unfortunate. The intent of the ordinance, and I was involved with the development of that ordinance.
Mr. Chairman, I
Yes, sir.
would object to Mr. Higgins' testimony regarding the intent of the ordinance, because we have to deal with the language of the ordinance. Now, just so the record is clear, I wanted to see if there was any legislative history regarding the ordinance, and based upon my Oprah request, there is none. So, unfortunately, Mr. Higgins may have personal knowledge that may not have transcended into the ordinance itself, but the ordinance reads, it says shall not be permitted. So that's why we're here.
And I have to respectfully disagree with that. If that wording was in another portion of the ordinance, it said billboards are not permitted anywhere in the Township of Ocean, then I would agree with the attorney. However, that wording is in the conditional use section of the ordinance. That is a condition of the conditional use in those zones in which billboards are permitted as a conditional use. So the fact that the billboard is being requested is a deviation from the condition of the conditional use. That's where it is in the ordinance, in the conditions. It's not a D1, it's a D3, and it's necessary to demonstrate why the site can accommodate the use despite the deviation from that condition of the conditional use. And what I've heard is that there are power lines that block the view of a billboard if it were constructed lower. I haven't heard anything saying that if a billboard were constructed further back on the site, and obviously it couldn't be 150 feet, but if it were constructed further back on the site, that give a better setback at a lower height of 25 feet, then it would be visible under the wires. And the other point is it's so close to the street, when you're pulling up, going down the highway, looking up at the billboard, you're not looking down at the exits from that site or any other sites right in the immediate area, which is one of the reasons why I thought it would be appropriate for the board to get its own traffic expert in this instance to look at that one issue. And I think it all goes to, and I also haven't heard anything about what other structures are located in the front yard that are 600 square feet in area, 45 feet in height, and within the required front yard setback within 25 feet of the street. And my observation in riding up and down Route 35, which I do every day, is that there are no others. And I think that in itself could be a substantial negative impact in terms of the character of Route 35. And those are the things I'd like to hear, because I have concerns that the site is not well suited to the construction of a billboard.
Okay.
And the other issue is that when you take the entirety of Route 35 and looking at the exhibit from earlier, and I think it's A7, I think it is, yes, A7, is that there are a total of forgetting the billboards that the applicant has gotten permission from to build from the DOT, but not from the township, there are 10. Of those 10, 6 are located on vacant lots, other than billboards. 3 are located on vacant portions, undeveloped portions of lots that have other uses on them. And 1 is actually located on a developed portion of a lot, and is very clearly one that's different than the others. But this would be very different from any other sign or any other billboard or any other structure on the entirety of Route 35. And I haven't heard any testimony to that effect, and zoning is required to give reasonable consideration to the character of an area. That's in the municipal land use law.
Okay.
Andy, you want to hit on some of those points?
And again, I'm
There's a
relying.
lot.
Sorry.
There were a lot, but if you want to hit
Yeah,
it.
there certainly were. So, this is a larger billboard and closer to the street. It is, in fact. There's no denying that. But the special reasons are for seeing through the wires, being above the buildings. And this sign is designed to be seen from further away than you would a 25-foot high sign that's set further back, because of buildings and wires and other obstructions that are in the way. So looking at the sign when you're close to it, looking up, it's not designed to do that unless you have a sunroof. You would be able to see it anyway.
The sign is not designed to provide a message for the use of this property. It's designed to provide off-premise messaging.
That's correct. That's correct.
Any other questions?
Will you be able to, it's in the parking lot, correct?
It's at the edge of the parking lot, yes.
So will cars be able to be underneath it?
And that's Bill can answer the question.
Just switching back to exhibit A3, that's the site plan rendering. So the billboard is to the left, and it's highlighted in this beige color. Sorry. No, the sign is completely outside of the parking or circulation area of the existing parking
But the
lot.
gray part is the parking lot up top, right? I mean, I'm looking at the top of the sign there.
That
it
is
looks
the
like it's over
rear
parking lot.
That's the rear. That's not for patrons. That is the rear fenced-in area for the auto body shop. So all the patrons, you or I, pull into the site, we would park in those head-in parking spaces. None of them are underneath the overhang of the sign structure above.
All right.
And that monopole foundation is located approximately 50 feet back from the DOT right-of-way. So we put the sign foundation as far back as possible, almost even with the building. The
Now, my
building
concern is I have a friend that had his car got a javelin basically went through it where a pole fell off one of these billboards through his car, and nobody wanted to take responsibility for it. So. I literally just went through the car like somebody's.
I was in the bike place and it worked out.
So the monopole foundation is set back approximately 50 feet from the right-of-way.
Right.
Mr. Schaefer, do you know, I have a question. Thank you for your testimony, sir. You may not have this answer, but do you know if another plot of land was ever investigated that where this billboard would be the only structure on the property, and then it could be set back farther?
I am not aware whether a study or survey is done for that.
Okay.
Yeah, I mean, that goes back to my question I asked, whatever, an hour or 2 hours ago at this point, is why was this location chosen? Because it seems like there's a lot of obstacles in the way, and rather than altering the billboard to avoid those obstacles and making it more variances required, maybe this isn't the right spot for this thing.
I thought that the applicant was gonna give us some testimony as to that, because you did ask that, and you advised that later on we would.
Yeah, I think, Mr. Steinberg, I could address that in my closing statement.
Okay.
Because it's permit as opposed to location, where you can put it.
That's basically your answer.
Right.
And your answer is they went and got the permits first to see where they could put it, and then they retrofitted it onto the highway.
But part of the permit requirement is coming for us and getting approval.
Well, but no, but
Before you
we're talking
actually do
about.
it.
Before you actually
The
do it.
distance
I believe the
was
state
the-
requires the distance between other billboards on the highway, so that if you grid it out, then there's only so many locations.
Right, but shouldn't you conduct your due diligence with the local town as part of your permitting process?
That's up to the applicant, if they wanna put the chicken, or the cart before the horse.
Understood.
Vice versa. But.
That was a rhetorical question.
Right, but it's a two-part system, one which they need their state permits, and secondly, they need their local approvals.
So the answer is these are spaced out as far possible to achieve the maximum number of this type of billboard within the DOT.
I would respond by saying the location is chosen based upon where it can be located on the DOT standards. It's not to maximize. The standard is you have to be 3,000 feet or so many feet away, whether static, multi-message, and the like. So that's what goes into the locational selection.
But it ignores what the town's ordinance says.
Won't say it ignores, but you'll hear more from me on that.
So we keep going back to the distance and the DOT permitting between the billboard. I'm sorry, I do. I keep going back to this. And in the planner's testimony, he discussed that and Jim, correct me if I'm wrong, that our local ordinance says that no existing billboards, no new billboards, but existing billboards that need to be rebuilt or I think possibly relocated or allowed. Yeah. So what is keeping an existing billboard from upgrading to a multi-message and not being able to use their permit any longer because we've approved an application for an existing multi-message billboard that's now within 3,000 feet of an existing static billboard? So through under the argument that we approved the application, existing billboards within 3,000 feet, existing static billboards, would not be able to be upgraded because they wouldn't get the DOT permit. Is that correct?
They wouldn't be upgraded to multi-message. Their permit is for static, and that's been identified on the exhibit that Mr. Vogt testified to earlier today. I believe those were A7 and A8.
It's 300 feet between a multi-message and a static.
Right.
So if they came to your board and modernized a static board to a multi-message board, they would still have to go through the same requirements, get an updated DOT permit from that static sign to a digital sign, and it would have to meet the same requirements. So it's 300 feet from a multi-message to a static, 3,000 from multi-message to multi-message.
So they would need to re-permit from a static billboard to a multi-message.
But they wouldn't be able to do it because they need to be 3,000 feet away from the nearest multi-message, correct?
Correct. So if you said you had an applicant that came before you that modernized their sign from a static to a multi-message, is that correct? So they are at least 3,000 feet away from another adjacent billboard on the same side of the highway, 3,000.
But the current owners of those billboards, static billboards, would not be able to get a new permit in their existing location to modernize their billboards, because these new billboards are going to be within at least 2 of the 3 applications.
Correct.
Are roughly, again, I don't have a tape measure on me, within 3,000 feet, or they're currently within the 300 feet, which is okay. I understand that, but they would be. So we're basically saying those current owners could not upgrade if these applications were approved. I just want to make sure I understand that.
So the applications, if you look back at this exhibit A7, on the southbound side of Route 35, which is all the yellow, you can see the next sign from our current location to the south of us is the existing out front sign. That's a static sign. They will not be able to upgrade that to a digital sign since we hold a permit for a digital sign that's within 3,000.
Because DOT's already granted you that permit.
So even today, they couldn't do it if they wanted to.
Correct.
Unless we give up this permit.
Got it.
And that goes for the northbound side.
Thank you.
Okay, so the DOT permit, what do they require in order to get the permit other than, I mean, what do you have to go through to get the permit for the DOT? What do you have to prove, or what do you have to show? I mean, I'm trying to figure out how easy is it to get this permit?
It's not easy. It's not easy. I just had one denied in Fort Lee from the DOT.
For what purpose?
It was too close to a gore from the interchange of Route 4 and I-95.
So there's specific requirements you just need
Correct.
to meet, and as long
They-
as
they
it's checking boxes?
It's not checking boxes. The DOT goes out and they vet the site, they drive the highway, they go through stringent requirements to issue that permit. It's just not given to these applicants. It's ultimately on them. If something God forbid does happen, it's on the DOT that they issued. They're protecting the public, just like the DEP. That's what they're doing. That's why we go and get these permits. They're here for you, not for, and I have to follow those rules.
Do they dictate where on the site you need to put it, or do you tell them where you want to put it on the site?
They do. They give you a map that tells you where the permit is issued for, and that's where we locate the sign and the distances that they give us.
But a piece of their approval is town approval?
No, they give you the permit for it, but you have to, as a outside agency approval, just like if I had to get a permit from soil erosion or the county or the DEP, you are an outside agency to their permit. So I have to come before your board and get a site plan approval.
Similar to you making a condition of a approval of an application being that they have to get somebody else's approval. So,
Thank you, I said that wrong.
How long is that permit valid for? Like when you have to start construction, but like
They are 5 years, and then you can renew them.
so theoretically, if this process took longer than 5 years, you'd have to get a new permit.
You renew your existing permit.
Yeah.
Any members of the public have any questions for Mr. Schaefer? You're not off the hook yet, Mr. Schaefer. Come on up.
Oh, sorry.
Remind us your name, please, and
Sermont, 192 Oakhurst Road. I might have drifted off here, so forgive me if this has already been talked about.
could you have a seat so the microphone
Sure.
can catch your
I
voice?
thought we were sharing the mic. Mr. Higgins' report has this at the very end of it. This site is located in a section of Route 35 that is designated in the master plan as an area to allow mixed commercial and residential uses with an ultimate goal of creating a walkable mixed-use area. The applicant should address how the construction of this billboard fits in with the goal of this master plan. I think we would all agree that the Orchard Street Plaza area is a disgrace, And hopefully the town will take some steps to spruce up that section of Route 35 and make it more attractive for everybody.
But you're asking
And,
how this
and
complies.
I'm asking how your application would fit in with that goal.
As previously testified by me and Mr. Vogt, the DOT had a part in placement of that sign, but it does still provide for the ability to not block the sidewalk in any way, shape, or form from pedestrian traffic. So it is not impacted in any way, both positively or negatively, the walkability of the sidewalk along Route 35.
Okay. Thank you.
Thank you.
Joan Dameray, 1633 Melville. Can you just fill me in on the administrative code for the minimum miles per hour on the highway that has to be for a billboard to be constructed?
That would be probably Mr. Intandola.
Right. It's probably better for him to answer that.
Is he here?
He's here.
Battery change?
Brian, to save time, sit here.
So, I'm not aware of a minimum for a state highway. Most state highways run from 25 miles per hour to 65, so it would be in that range. And that is accounted for when you go through the NJDOT process. They look at what the speed limit posted is.
So I just looked up the code, but I don't know if I'm looking it up correctly. So just as a point of clarification, and I imagine it would have been caught in the permit process from NJDOT, but they generally say that the minimum miles per hour would be 55 miles per hour, and I don't believe that Route 35 is 55. I believe it's 50. So I'm not sure.
Yeah, I don't know.
It's just a point of clarification.
Yeah, I don't know if that's a limiting value for a billboard, because I know of other areas that have 45, like Route 46 is.
I'm just asking
Yeah,
for clarification.
I don't think that.
Or the
I don't-
board should ask for clarification from the, from the DOT that.
Well, if you could see if I could read your citation, I would be glad to look at it.
It was under, I don't have I do, sorry. 19:4-8.14, then you go all the way down under billboard, and it indicates that the right-of-way should be a minimum of 55 miles per hour for a billboard.
Right-of-way is width. So I don't know how right-of-way.
Well, ROW?
Yeah, that's
Right.
width. That's the width of the
Right.
the width of the.
It says 55 mph minimum.
Right, so that seems to be erroneous, because right-of-way is the width of the road versus the speed of the road. So I don't.
It says here, notwithstanding the provisions table, billboards shall only be permitted within a ROW, right-of-way, having a posted speed limit of 55 miles per hour or higher.
Yeah, I don't know if that's.
We don't
I
have the
know
answer.
citation.
Anyway, we can check that.
Give us that citation again?
It's 19:4-8.14. But you know, when you look up the code, you're not always getting the most current. I can't.
Right, so that I have that problem too. Sometimes it sends you to.
Right, so I'm not, I'm
It says
just
you-
pointing it out that I don't know if,
I have that
it's
issue
clear
myself.
that, right, Route 35 is 50 miles per hour. It's not 55.
But that is
So right off the
considered,
bat.
as Mr. Voigt said, that is considered in the vetting process. That is.
I'm aware that
strenuous.
obviously DOT had to look at the permit, correct. I think that was my only question. And then the only other question I had was, it shouldn't be within 500 feet of the neighborhood. So again, where the Mavis is, there's houses right there, and there's actually a house closer than the Mavis to Route 35, which would probably bring it within 500 feet of the sign
Again,
across the highway.
the permit is in hand, and those factors have
So
been.
our 500 feet in our township also.
Well, that's why we're here.
Yeah, but I believe the statute also indicates, the state statute says it can't be within 500 feet of a neighborhood,
Yes,
a residential neighborhood.
Yeah, that has
It's in
been
the administrative code.
understood, but I do not know, as you had said, if that administrative code is current Because anytime I look up an administrative code, I always get the one 10 years back, and you have to go to the LexisNexis to get the current one to make sure it is current.
Well, there's a lot of attorneys here, so I'm sure we could get the answer.
Oh, they all have LexisNexis accounts.
That's
No,
correct.
I don't.
I'm just here to ask the questions.
Understood.
I'm not the attorney.
Nor am
I.
Thank you.
Just to clarify, the New Jersey Administrative Code Title 19 is Other Agencies New Jersey Meadowlands Commission. So I don't think that would apply to
okay.
this corridor.
Oh, right, yeah.
There it is. Thank you.
Please just clarify the 500 feet and the miles per hour, regardless of the
Well, like, so what the CME Bennett has said, it applies to the Meadowlands around Giant Stadium. That's their own, because they have their own transportation district that is empowered by the legislature, that they have their own rules and regulations for that corridor. So, like, I don't know if you know Bergen County and that area, they have their own special carve-out area in the Meadowlands to write their own traffic regulations. And I think that reflects that.
Any more questions for Mr. Schaefer or anyone else? Good evening. Could you just state your name and your address?
Chris Cook, 2000 Sunset Avenue. I wanted a question for this gentleman.
That would be Mr. Schaefer.
How are you?
Good, how are you doing?
Interested in the public access to the signage and the information that I can provide, like Amber Alerts and
We can't hear him.
I'm interested in the public access to the information that your billboards can, the towns and the information. Billboards are for information.
Yes, that's correct.
How do you manage that? Who has access?
Well, somebody in the town would be designated to do that and provide the gatekeeper, if you will, of what other folks, agencies, or whatever could have access to it. We would also probably have to explore county access to it, maybe even state access to it. And everybody's technology is a little different too. So every town's access is going to be a little bit customized based on the age of software, hardware, things of that nature, and they would have to come together on a case-by-case basis. But that is still one thing we're offering, which actually leads this, begins to lead this under the MLUL to the state laws, that it could be considered an inherently beneficial use in the town because of the access the town would have for public service.
So for missing children, Amber Alerts.
Exactly. And that's exactly what I'm referring to, one in particular, but there are others. I mean, school closings, snowstorms, weather alerts, there's a number of different things that it can be used for.
That the static doesn't and the multi-message does.
Correct, the multi-message does, static does not.
And that is on all of your all of them?
All the 3 that are applied for?
Yeah, you're going to be able to have access on that access.
2 out of 3.
Okay. That's all I have.
Thank you.
Why 2 out of 3 and not all of them?
Static thing.
Oh, but I thought you had 4 boards, and so far. And 1 is a static, and the other 3 are multimedia.
The other 2 that are here are multi, and the other one has guitar.
Okay.
Any more questions from the board? Any more questions from the public?
Yes.
Sorry? Well, if you have a question of one of the other witnesses that didn't get asked.
I have a question about something that hasn't been brought up.
Yeah.
Actually, maybe that's,
that maybe our experts can help with. Yeah, that's.
or should that be part of her statement?
Let's hear it. Come on up. Come on up.
Don't decide.
Remind us your name again.
Diane Sarmont. My question is, other than the maybe public messages that we might get, what are the benefits to the town and what are the benefits to the citizens of the town? Is there additional tax revenue? Is it prorated? Is it, what is the financial benefit to the town to approve these?
Number one, financial benefit, taxes, etc., are not to be considered on zoning applications
Okay.
by the board. That's number one. Number two, you can give a comment period, which is coming up now. All
That's
those
fine.
comments to the board as to why they should vote for or against the application. But the board is not, because it's a bigger rateable, it's not a reason for the board to grant an application. They're
Okay,
not supposed
I didn't
to-
know that.
Yeah, they're not supposed to.
Okay, thank
think
you.
of money.
Don't leave. Don't leave.
Have your
Oh, you want
comment.
my comments?
Yeah.
We're done and we're ready for public comments?
I'm not sure. Any more questions from the public?
Said it. John said he's wanting.
Okay.
Okay, there's
So
been
before you begin, that now
sorry.
we have to swear you in. So,
Again?
yeah,
Yes, oh,
right,
okay.
Right? For testimony, right?
Yes, that's
Yeah.
testimony.
Okay. So do you swear the testimony you're about to give is the truth and the whole truth?
Yes.
Okay.
Just ask questions.
There's been a no new billboard ordinance in town for 32 years, and I don't want to date myself by saying how long I lived here, but a long time. The whole time I've lived here, no one has ever came up to me and said, "I really wish we had a 45-foot double-sided digital billboard to distract us as we drive down Route 35." I am not sure that there is a valid public use for this, other than maybe some public notices that we all get on our phones anyway. The aesthetics of the billboard, I think, will be very unattractive. We currently look at trees in that spot as we drive south on Route 35. If the extreme height of the billboard is being driven by the height of the poles and the wires, then this is not the spot for this billboard. And I encourage you to vote no on this application.
Okay.
Thank you.
Hold on. Does
What?
anybody have any questions? Mr. Chakowski, do you have any
No
questions?
Okay.
Thank you.
Thank you.
Thank you.
Good evening. You state your name and your address again?
Elliot Catan, 28 Old Farm Road, Oakhurst, New Jersey.
Okay. Can you raise your right hand, please? Do you swear the testimony you're about to give is the truth and the whole truth?
Yes.
Thank you.
I'm very in favor of billboards. I think they help tremendously with local businesses. It gives them an opportunity to advertise to the local community, and I think they just help a lot. When they say there's no benefit to billboards, I think there's a tremendous benefit. Besides the fact also of the public service that it provides, Amber Alerts, FBI alerts, county alerts, stuff like that. So I am in total favor of billboards. I'm in favor of all three right now. Thank you.
Anybody have
Sir,
any
what
questions?
is your business?
I am retired.
Oh, thank you.
Your name and your address?
Murad Katan, 333 Park Avenue. Park Avenue?
Can you raise your hand? Do you swear the testimony you're about to give is the truth and the whole truth?
Yes.
Thank you.
I grew up here my whole life. I'm a graduate of Ocean Township High School. I've been in marketing and advertising for e-com based for digital for 12 years. I do believe that I'm in favor of this billboard. I'm in favor of all three billboards. I believe from a community perspective, when you think about advertising these days and you think about, trying to reach your target customer in a localized area like this where you have, 30,000 or 20-something thousand people driving through Route 35 every day, and you're able to target the individual customer within your community and speak to them. It gives local businesses the opportunity to do that. It's not easy to market to the customers. It's not easy to talk to your town and target those locally. And I find it to be a great opportunity for those locally to do that. I'm in favor of all three.
Do you or any member of your family have any financial interest in these billboards?
No.
Anybody have any questions? Any questions, sir?
No questions.
Thank you. Anyone else like to offer testimony? Come on up.
Joan Dameray, 1633 Melville Street. Sign, swear in.
Oh, yep. Do you swear to tell the truth, the whole truth?
I do.
Thank you.
I'm just here to, I'm opposed to the billboard, the one we're discussing now on Route 35. Right now, between Deal Road and West Park Avenue, I believe there's already 5 billboards. This one would probably be number 6 in that small section between those 2 intersections. There is a significant neighborhood, which is where I live, right behind, right across from where the billboard is being proposed. There's a cross street called Talmadge Avenue, which goes straight back to the Joe Palais Park. So if you're standing in the center of Talmadge Avenue looking west, no matter what side street you come out of to make a turn, when you look west, you're going to see a 48-foot lighted billboard at night, which is, I believe, a pollution intrusion for the light towards our neighborhood, as well as an eyesore. We have a new development to the south of us, which has a tree line. There's enhanced noise from over there. So it's just, I just can't believe now that there's going to be a billboard straight out on this side of the entrance to our neighborhood. I live in the south section of that parcel, a few blocks back, so I won't necessarily be able to see the billboard from my house, but there are homes on the corner of Belmore and Talmadge, which are in the road right behind the STS or Mavis, which was mentioned, which is going to be in very close proximity to that very tall, very bright, moving billboard every so many seconds. So I just don't think it's appropriate location for such a large structure. It's very close to the highway. It's going to be visible from pretty far away from many of the people who live in that neighborhood. So I'm here to make my testimony that I do not believe it is an appropriate location for that tall and that lit up type of a structure so close to a residential neighborhood.
Anyone have any questions? Any questions?
No questions, Mr. Chairman.
Thank you very much.
Thank you.
First meeting ever.
State your name one more time for us.
Chris Cook,
And your address.
2000 Sunset Avenue.
And do you swear or affirm the testimony you're about to give is the truth and the whole truth?
Yes.
Thank you.
I thought I'd come out and see what you guys are, what you do. And
Just get closer to the microphone.
I thought I'd come out and see what you guys do. And wow, billboards, huh? As I think about it, Route 35 has been commercialized a lot. I'd rather see some billboards that can put out safety messages and Amber Alerts and information than more stores. I think the benefits to a billboard outweigh what we've been doing to Route 35. It's been commercialized a lot, but I think this is less intrusive than more stores. So I'm in favor of that. I'm in favor of billboards rather than stores.
Okay. Any questions?
No questions.
Thank you very much. Would anyone else like to offer testimony? Okay. Floor is yours.
Chairman,
Or do we close the public hearing now?
Well, I think we're gonna hear a summation,
Mhm.
and I think the board then needs to discuss how they wanna handle this, given the information given by our professionals. We can close the public hearing, there's nobody else to testify, unless the board wants to reopen it at some other point, so it would be appropriate.
But if we have questions following his summation, then,
Yeah, then-
okay, so let's just go ahead.
I would leave it open, because we may wanna, the board may have some questions of the experts.
Thank you, Mr. Chairman, and as I indicated, I did disagree with Mr. Higgins because we're faced with an ordinance that has very specific language that says the construction of new billboard signs shall not be permitted in the Township of Ocean. And then it goes on to say if you have an existing billboard and it continuously says the rebuilt or relocated billboard. So that existing billboard is the only one that's protected by this ordinance. So we have to look at the constitutional dimensions of what that means. And what that means is that the total banning of a billboard by a municipality is a violation of the First Amendment. And there are a few cases. There was Metromedia out of the United States Supreme Court, and we have E&J Franklin out of the New Jersey Supreme Court that basically says a message on a billboard is a form of protected speech. And now we go, why are we here? We are here for a billboard that A, we know is constitutionally protected, and B, will require some relief from this board. And what is that relief? Well, first, the safety and other requirements, the basic requirements regarding the location of the billboard, have been determined by the DOT. As been testified by Mr. Vo, Mr. Intendola, there is a process, and it's not an automatic process. There may be reasons, safety, that are not check the box reasons, that a permit will not be issued. And if you have the list of permits from the DOT, it basically gives you a location, but that location may be from a mile marker, from an intersection or the like, and that will tell you where that should be. So that's really the first step. The DOT is the one will determine along state highways. You still need local approval. So when we go to that local approval, what did we need here? A use variance. Now we kept hearing the phrase special reasons. Special reasons has been determined to be site suitability, and this goes to Mr. DeGennaro's questions about why here. One is because of distance, but with use variances, we had two seminal cases. The first you've probably heard all the time, Medici. Medici was an '84 case, and it basically addressed that, you know, there are some uses that you didn't consider. The courts went haywire. And what I mean by haywire, it was almost, you could not put this anywhere else. And therefore, you had to have the one location. So then there was another case, Price versus Himeji out of Union City. I happen to be privileged to argue that case in the Supreme Court. And that court 20 years later, after Medici, says, it doesn't have to be the only location. Is the site suitable? So we don't look at other locations. So we're asking for a few variances here on the D side. One is the use. It's not permitted, we know that. But we can get over that hump by saying that outright ban, it should be permitted based upon that factor that it's constitutionally protected. And then you get to the height. And what is the reasoning for the height? If you look at the various exhibits between both sides of the street, you have the impact of the utility poles. And again, you're dealing with visibility and safety, and that's the reason that we are requesting the height of 45 feet. Now, when we look at the existing conditional use ordinance and the like, it basically says 25 feet. I would submit to the board today that an ordinance in 1992 that had no idea what a multi-message billboard would be should not apply here. So we're looking at the building height of buildings, and you would of course have a sign over the building so you could see it from the roadway. The other is the front yard setback. You are requiring a front yard setback for a billboard sign for what a building would be. And when you look at that, it's like, does that make sense? The answer is no, because if you have a freestanding sign, which this is, just happens to be a larger one, that freestanding sign itself would have to be able to convey a message in a safe and efficient manner. Now, when we look at this, is that we know, and I'll just walk away from the mic, we see this billboard here with the two sides. However, there is a pole that is, if I accept Mr. Voigt's testimony, not a significant structure in terms of its width or its girth, probably a better word to use. And then you have the sign above it. So there's minimal impact on the ground. In fact, on the ground, we're not disturbing trees, we're not disturbing parking, we're not disturbing ingress and egress. Now, when we go to the negative criteria that we've discussed, is there detriment? Now, the statute is pretty clear. They threw the words substantial. There's always some sort of detriment. If somebody builds a deck and needs a variance, there's going to be an impact. I like to use the word impact instead of detriment. But is it substantial? What's the substantial impact here on this area that has been determined by the DOT to be suitable for billboards? We may not like multi-message boards, but there's nothing to indicate that this would have any impact. And the cases that I just cited is that aesthetic reasons really shouldn't come into play. That's a pretense for certain actions. We know what billboards look like. So the question would be is that what would be the other impact? Is there a safety impact? Is there any other impact? We haven't heard it. We've heard some members indicate they don't like billboards and others that do. And then is that, will there be a substantial, will there be an impact on zoning ordinance or master plan of the municipality? Well, this ordinance has existed for since '92, and there's really nothing in the master plan that addresses billboards since that '92 ordinance, which we know dealt with, let's keep the existing. And I believe Mr. Higgins said that there was nothing prior to that '92 ordinance which regulated billboards. So when you put it all together and you look at this, and say we have a constitutional mandate to provide messaging that's protected speech, which is a billboard, and is the site suitable? I think you heard that this site could accommodate the use and it's suitable, and applying the case law of Price versus Himeji, that case indicates that you don't have to look at other locations to determine suitability. You look at this location. We need one other variance, and that is you have multiple uses on this lot. You have a collision center and a billboard. Now you have on Route 35 several multiple uses, and it's what I always call the Wawa example. You have a gas station and a convenience store. They function together. So that's the best way to look at multiple uses, is do they function together? And if they function together without impacting one another, my Wawa example is one builds off the other. In this example, nothing builds off this because it is a passive, totally different type of use, which is only to convey a message. And as Mr. Vogt testified in the July hearing, is that there is just maintenance that is done here on probably quarterly basis to the site. That's the only visit to this area. So I submit to the board that there are sufficient proofs to grant the variances requested, and I wish to thank the board for their consideration in scheduling the special meeting. Thank you.
Thank you. Mark, can I ask you what you think of the quick jump to the constitutionally mandated speech?
I understand that no billboards, it may be a violation of First Amendment, but that's not the job for this board. This board has ordinances for which they are seeking relief from. If they feel that the ordinances in town are against the unconstitutional, they need to go seek that relief in municipality. You don't have the right as a board to say that the ordinance is unconstitutional.
Or approach the township to rezone, which is never done.
Yeah. So, I mean, you don't have the power to do that. You have a power to decide whether or not they've established sufficient proofs to prove the variances they've requested. That's all you have. You know, if our entire ordinance is unconstitutional, which I'm not saying it is, that determination has to be made either by the mayor and council or in an action against the municipality to change the ordinance. That's not you. You have to decide whether or not you feel that the proofs presented are sufficient enough to grant the different variances that have been requested.
Does anybody have any questions?
I do, I just don't know how to word it.
We'll give you a minute.
Yeah. It's late. So going back to the constitutionality, I understand that we can't determine whether or not we can't take that part into account, but what we can take into part is the existing ordinance about no new billboards from 1992 in our decision. Yes or no?
They need a variance, and that's again,
And that is a
questionable.
variance
That's
for
again
that ordinance, right?
Well, then questionable whether or not they needed D1 or D3, because our planner says that provision is not under the prohibition in different zones. It is under the conditional use that you can have a billboard, but you can't have any new ones.
Yeah, that was going to be my question.
And that becomes a D3, which is a different type of proof. So that's you know, that's an issue in itself. Whether, and then that proof would be whether or not the site is suitable for this. Not far off from the D.
Yeah, whether the site can accommodate the use despite the deviations from that conditional use requirement.
Which is not that much different
No, it's not that much different.
than having the proofs necessary for a D variance, based upon the fact that the height is substantial, the setback sort of adds to the height, which is substantial, and it's not permitted in some form or
Basically,
fashion.
yeah. And there, with that, the negative and the positive sort of mesh together into one decision there.
I'd remind the board too, we denied a applicant that was trying to build a house on Deal Lake a couple months ago because of the height.
Questions?
Well, the package that's presented to you was 45 feet, 25 feet from the road, you know, less than 25 feet from the road, right?
Yeah.
For the edge of the sign.
Yes.
It's the pole itself is, and it's only requires 150, which is maybe too much. It's based upon the, and then there's two uses on the site. So again, I don't know, you heard some planning testimony, and of course in the summation, but you know, I don't know if you akin this to a Wawa, which has a gas station which feeds off of the convenience store, etc.
It seems to me that
unless the sign, a piece of the sign falls down and the guy wants his car repaired, I don't think it'll be any.
Well, the other thing is like
joint uses.
I understand the attorney's analogy, but as it applies to our ordinance, a gasoline station convenience store is one use. It's not two uses. But I understand his making the analogy that you have two separate functions on the site, even though it's one use.
Do you have anything to respond?
Only thing I would say, Mr. Chairman, with respect to a conditional use is I don't disagree with what I've heard from Mr. Higgins. A conditional use is a permitted use subject to the conditions. If you deviate from the condition, it's one of site accommodation, which the site suitability testimony would cover.
Okay. So the disagreement over what kind of approval?
I don't think that's major. Okay.
Yeah, but let me finish. It has to be settled, though, right? Or I mean, actually, it has to be settled if it's going to be approved, right? So if somebody's going to make a motion to deny, and it was denied, then we don't have to settle that question. Is that right?
Well,
am I asking that properly?
Jim's our planner.
Yeah.
And Jim feels that this is a D3 variance. I think the.
Oh, we just go with our planner. We don't have to settle that. I mean,
Yeah.
that might not sound.
to go with it.
No, it's no. We would take your advice, and yeah, I understand.
No,
Yeah.
I find this to be a D3.
Yeah.
Which they did present. Their testimony that was presented was similar, and would apply to each variance. The straight D, which is you can't have a new billboard, or the D3, which also says you can't have a new billboard, in certain zones. So the board can decide how they want, but I think the testimony was supplied for either one.
Okay.
Whether or not you find that to be credible and acceptable is the second story. And then you have to mesh them all together, because in addition to the D1/D3, there's the height and the setback. Now the height is also another D variance, which requires 5 affirmative votes. Again, because the legislature, in doing municipal land use law, felt that height in excess of 10% of what is permitted is a substantial differential, which requires the 5 affirmative votes, which shows you that it's a more important variance to think about and grant. So you got the D1/D3, we'll call it that. We got the D6, which is the height.
And then the D1 for 2 uses.
And then the D1 for 2 uses, because in our municipality, we say that you can only put 1 use on a site.
And then there's C variances for setbacks.
Well, that's C variances, yes. Then we have some C variances for the setbacks. Yes.
So how many votes do we have to take?
Yeah, I got a question. Claire, do I have a vote tonight, or is it, did the alternates vote, or how many do we need?
So, okay, no, we can only take 7 votes.
Okay, so how many people?
I don't know if anybody's recusing on this, or
No, not here.
5 what? We have 5 regular members.
But how many can vote?
7.
So, as long as everybody's.
1, 2,
We all
3,
can vote.
4, 5, 6, 7, 8. Somebody doesn't get to vote. Who's low man on the totem pole?
It's not me.
It's always me.
Chris.
Here it's me.
Well, Chris doesn't get to vote, but he gets to. You get to participate in the conversation.
Thank goodness.
I tried.
No. That's
tried to keep.
No, it's key.
You know, I don't know. And then the other question was, is we talked about whether or not you felt that you need some of your own independent verification as to the safety or the 8-minute situation from someone who has more experience in traffic engineering.
I don't need anything else.
I don't, does anybody need anything else?
All right. So can we have a motion to close the public hearing?
Motion to close. Second.
Claire, take the roll.
I'm just gonna raise my hand from now on.
Yes.
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 Yes. Yes.
Yes.
Yes.
Yes.
Does anybody want to make a motion for a positive or a negative resolution?
I'd like to make a motion for a negative resolution.
I'll second it.
Claire, call the roll.
As you call the roll, I think the members should tell us why, so that I can know in reviewing my ability to, not reviewing, but in my ability to write the resolution and find out the reasons that you feel that you want to deny it.
We vote
You're gonna
yes.
vote yes. The motion was made to deny. When you vote yes, it's to deny, and just give me, brief synopsis of why you feel it should be denied.
Do I vote yes
Yes,
on no or no on no?
Now you're voting yes.
You made a motion to deny, so you want a yes to the
on the
motion.
no.
Why?
Yes, and why? I think the structure is entirely too large. It's entirely too close to the road, I don't agree with the 25-foot setback. Do you want me to go on?
Oh, sure. If you can.
I can.
Good.
I would have liked to have, I can address you directly, sir. I would have liked to have seen it in a different spot. I think if it was located on a plot all alone, where it could have been set back 150 feet, it would have potentially been better. I don't agree. I don't like this. I just think I'm not comfortable voting yes on this particular application in this form.
Thank you.
Yes. And for pretty much all the variances that they're seeking, multiple use, and even though the ordinance was a while ago, it was done knowledge, the height as well, so for those reasons.
Yes. I think notably the D6 variance for height, there wasn't sufficient testimony to argue that that is logical or reasonable. Yes. I would agree with everything everybody said so far. I mean, the site is not substantial to support this application. The benefits of public announcement, to me, is not enough to support this case and be able to prove it, and that's the one benefit that I see from this case.
Yes, kind of echoing the same comments. I just don't find the beneficial use of putting this sign up. I do agree with the public service announcements, but I don't think that's enough to justify the rest of the use of the sign.
Yes, and I think it puts the board in conflict with past cases that we've ruled against, and one that I know is coming up where they're going to try to resubmit it. The height setbacks, I think it falls outside the scope of the master plan.
Yes, I did not hear anything that would compel me to offer exceptions to the ordinances that we have in town regarding additional billboards in town, the height setback, the height and the setback, and the dual use. So I just am not convinced that any exceptions are needed here.
Right. Thank you for your consideration. When can we schedule the next two?
We're not saying for those.
The night's young, isn't it? What do?
Well, we would
carry it tomorrow,
Well,
or no? We
we're
can't.
not
We
gonna
won't be able to
carry it
figure it out.
tomorrow.
Yeah, we won't be able to figure it out in a day.
You're looking for another special meeting?
Why
To
don't-
discuss it?
Why don't we carry it to a date certain, whether we're going to reach it or not, so we can discuss
Well,
the special
our
meeting? I
next
think your
meeting-
regular meeting's tomorrow.
Yeah, so then October?
So, we would carry it to the November meet. When's the November meeting?
No, October.
I'm sorry, October meeting. October 9th. We're gonna have an answer by October 9th, because we moved that up because of Jewish holidays. Maybe you should carry it to November. It was time to, you're not gonna be able to figure it
No,
out.
just if you have an October meeting,
All right, well,
for scheduling purposes, so for
Okay.
October 9th, is that the meeting date?
So the.
But you're only gonna give 31
I understand,
But he's gotta figure out-
I just wanna be carried so we can give the notice.
Yeah, so basically, the two other cases on tonight, which is INTT Services LLC for 92 Highway 35.
922.
922, and the other one is
1418
Highway 35 are carried to the regular, well, the October 9th, 2024 meeting with no further public notice required. That's the second one, right?
Correct. Thank you.
Can we have a motion to adjourn?
Second.
Second. All in favor?
Aye.
Thank you, everybody. Have a good night.
This ordinance.